Sister, how are you? Are you registered, sister, yet?
Yeah, this is
Oh, okay,
my
this is
dad.
family. Okay,
Yeah.
perfect. Okay, great. Then you can do it online. You don't have to do it. You can just
जी
take a.
जी
जैसे आपका you know, you can just take a.
हमने कल रजिस्टर कर
कर
लिया
लिया?
था जी
Okay, then you don't have to worry about it.
okay
If you're registered,
Daddy,
then
I already registered us yesterday.
चलें छोड़ दें फिर छोड़ दें आपने रजिस्टर किया हुआ है इन्होंने. तो आप अभी खाना एंजॉय करें और चाय पिएं.
शुक्रिया आ जाएं
Have you registered yet? Yeah, online, yes. Yeah, you did. Alhamdulillah, mashallah. Then you know. Yeah, yeah. You just enjoy food. Assalamualaikum. Like you look pretty serious. Why?
Yeah, Kyle. There is Muhsin.
कैसे हैं आप?
Hello. Assalamu alaikum. Welcome to Endowment Fund Committee seminar. We will request everyone to finish their lunch. We will be starting our program soon, in next few minutes. So please take your seats. And if you have finished your lunch, maybe you can come to the front. We have many seats on the front available. So please try to move to the front if you are done with eating. Inshallah, we will be starting our program soon. Nashad, where's Nashad? Nashad. Yeah, Mohsin.
Mohsin is the model.
Where is he? Where is he? Mohsin? Mohsin?
जी.
मेहंदी है ना just leave it for मेहंदी here.
Yeah.
Yeah, yeah. वो check करो. ये तो किसी का लिख रहा है. Yeah, yeah. इसकी
So we will be closing the lunch in next few minutes. If you have not taken the lunch, please go ahead and help yourself.
registered. If you have
Yeah. By the way, if you have not registered online or not here, so please remember to register so that we have your phone number, email address, and inform you about the future programs. Right on this table at the entrance, anyone who has not registered, please make sure that you have registered yourself. Mohsin, where are you? I will ask Brother Mohsin to come to the front and start the program. Bismillah.
हसन मेहदी. जी. शुरू करें.
Assalamu alaikum. Can everyone please take a seat? There are some seats available over here in the front and side. Okay, let's get started. Bismillah ar-Rahman ar-Rahim. Good afternoon, everyone, and welcome. Thank you so much for coming here on a Saturday afternoon to the Will and Estate Planning Workshop. This is a topic that I think is very overlooked in our community, but it's very practical and spiritually significant for all of us. So hopefully we all get some information today out of this program. What we are going to do today is we'll begin the program with the recitation from the Holy Quran. Then we'll have a brief introduction to the work of the IEC Endowment Fund Committee. The IEC Endowment Fund Committee is who is sponsoring this program. And we'd like to tell you a little bit about what we do, what we have been doing, and basically the agenda here. And then we'll have the speakers. Maulana has been gracious enough to come here and talk to us about the Islamic perspective on will and inheritance planning. And then we have Sister Sidra Khwaja, who will cover the legal aspects of estate planning. And finally, Brother Ali Danji will wrap it all up with sharing financial strategies to help translate all of these concepts into action. We'll do Q&A. I know a lot of you have a lot of questions. I know some of you have submitted some of these questions online. What we'd like to do is just to get through the presentations, we'd like to have the questions towards the end. What we'll do is for each speaker, we'll do a few questions at the end of that speaker's presentation. We'll take a few questions, but then we'll have a much longer Q&A session at the end with all the speakers here. So appreciate your patience with that. And then we have, a lot of you have registered online. We have the QR code at the table when you walked in here. We also have a paper. If you have not registered, if you have not put in your name and contact info, please do that. That helps us understand who was here. It helps us understand how to get you in touch with other programming, with the speakers here, if you would like to do that, and also to send you information after this session, because we'll share the information that we provide today and some additional information with all of you as well. Great. To begin our program, I would like, we'll start with a short recitation of the Holy Quran. I invite brother to come and speak. Please recite a salawat.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين صدق الله مولانا العظيم صلوات.
Jazakallah khair for that beautiful recitation. To share more about the mission of the IEC Endowment Fund Committee and how today's workshop fits into the broader community initiatives, I'd like to invite Brother Naushad to come and speak.
Stand there. Assalamu alaikum, everyone. My respected Resident Maulana Farhat Abbas, our guest speaker, Sister Sidra Khwaja, our own Ali Danji, and my respected sisters and brothers, Assalamu alaikum again. On behalf of the IEC Endowment Fund Committee, it is my honor and privilege to welcome you all to today's seminar on will and inheritance planning. We are delighted to see such a wonderful turnout, reflecting your awareness and importance to planning for the future, both for ourselves in meeting our Sharia obligations, and of course caring for the loved ones that we leave behind. As you know, the topic of wills and inheritance is not just a matter of legal paperwork. As Muslims, as Shia Muslims, it is our mandatory obligation to be prepared when we depart this temporal world. Too often we delay these essential conversations or shy away from them, but today take this as an opportunity to change that. By taking proactive steps, we can make a meaningful difference in the lives of those who matter most to us. Sometimes I talk about this. I've been doing this and learning and encouraging others to do wills for quite some time. And in my conversations in the chai halls downstairs sometimes, I commonly hear, "Yaar, let's not talk about this because this brings death closer." So I give them my example. I wrote my first will when I was 40 because Imam Ali said, when you get to 40, it's time to think about departing. So I've had my will for now 30 years, and I'm still around. And my family is still waiting for it. So maybe they have to wait for a little bit longer. On behalf, the Endowment Fund Committee took this step to arrange for this because not that we want you all to leave your inheritance for the endowment fund, maybe a little bit. But we think it's important that we as a community have these things in order. I remember a couple of years ago, and Maulana, you remember one of our marhum's longtime member. He was in his 70s. He was in a wheelchair. And I approached him a few months before he died, and I said, I won't mention the name because he's now marhum. I said, please, let us help you. You know, you've been here so many years, you have assets, you have houses, you have kids. नहीं अभी तैयार नहीं हूँ मैं. Oh, तैयार नहीं हुआ, somebody else was तैयार for him. And within, I think it was less than a month, Maulana, if you remember, we talked about it, and he unfortunately died. We don't know what happened after that because we were not in touch. The paperwork was not in order. So please, if you have one, Mubarak to you. Maybe it's time to update after every 5 years when your situation changes in your family status. If you don't have one, this seminar hopefully will help to give you a Sharia perspective, a legal perspective, and a financial perspective. It is not going to answer all your questions, but it will give you a platform from which to begin the process. And now briefly about the Endowment Fund Committee. The Endowment Fund Committee was set up some 30, 35 years ago, and the pioneers of that are here. Brother Hassan Khan, Brother Jafar Norshadi, who had such great vision for this community. They started this fund, and over time, it lacked the attention, It lacked the momentum, and it kind of stayed along till about 2016, when a group of us, Brother Hassan Khan, again herded us together, forced us every Friday to come here and talk about it, and then he would buy us lunch. But eventually we got a charter executed by the board, and the board then appointed an endowment fund committee. If I can have the first slide on that, on the endowment fund, just a couple of slides. I don't have much to share really. So there's a member of 6 people in the committee. Most of them are here. Brother Nusrat Zaidi, Mehdi Rizwi, myself. Who else am I missing? Mohsin Ali, the moderator. And then our young Brother Hassan Ali Poonawala, who is the treasurer of both the IEC and the endowment fund. And then we have a board representative. The chairman of the board is normally on the committee as well. So in 2018, the board said, the committee was formed. We took over about $21,000 in assets, mutual funds, and people had donated some shares of stocks. Between 2018 and October 2025, that $21,000 has now become $596,000. That's a 30-fold in 7 years. Now, a little bit less than half of that was donations from members of the community. And the other half, we reaped the advantage of the market. So, if we can have the slides. They're coming? Yeah, oh, it's like lunch, it's coming. So, there are 3 parts of the endowment fund that builds the platform. One is this marketable securities, which is the most liquid part. We invested Sharia compliant in mutual funds, in ETFs, in individual stocks. And we have Brother Ali Danji, who's taking care of that at R.J. Raymond's. We are open to discuss this to any person who wants to know more about it. The other platform is we have quite a few people that have purchased life insurance, whether it's term or whole. In some cases, the entire insurance, and the entire life insurance is to the beneficiary of the endowment fund. In some cases, a portion of that. The reason I bring it up, this is one way that you can leave some of your inheritance for the community in the future. This is Sawab-e-Jariyah. This is perpetual Sawab. The third part, which is not as common, we had one lady bequeath, which means that it's a physical asset, a house in Houston. That kind of gives you a breakdown of the total endowment fund. So the house is valued around $400,000. So if we take the marketable securities, the life insurance beneficiaries, now life insurance, of course, is not marketable. It comes only when the person departs. And the property is the same way. But in total, we can say that we have $1.3 or so million in the endowment fund. Our goal is to bring this to $5 million by 2030. And as most of you know, endowment funds are created so that we can support the organization when we have enough principal built. For example, if we can bring this to 5 million and generate income from the principal of at least, maybe let's say $10,000 a month, we could then see 10,000 being used for IEC for its day-to-day operations. And IEC, mashallah, keeps growing. What used to be 10K, 20K, 30K, I think Hassan Khan, we're close to 50K now. So that type of fund will help IEC. And in brief, I'm just bringing this up for the community to know that we have the endowment fund. We are not here to solicit any funds, so please stick around. Don't leave too early. And we just want you to keep this in mind when you write your wills. If you have enough for your family, you feel secure about your kids, they're all settled, a little bit to the IEC endowment fund This IEC community that has done so much for all of us, for our children, and now our grandchildren, we owe back to the community. So with that, I hope this is an interesting and informational session. We'll be here, the speakers will be here to engage and to answer your questions. Wassalamu alaikum wa rahmatullahi wa barakatuh.
Thank you, Brother Naushad. I was reminded that I didn't introduce myself. So for all of you who have not met me, my name is Mohsin Ali, and I am honored to be one of the newest members of the IEC Endowment Fund Committee, as well as one of the newer members here at IEC. I've been warmly welcomed, and I have met a lot of you, and inshallah, I look forward to meeting the rest of you as well. I moved to Houston about a year ago from the Bay Area, and I was pretty nervous about moving to Houston, but now I've gone through 2 summers, so I feel like I'm a native, hopefully. Although I've been told that I haven't seen the worst of it, but here I am, and I'm amazed by the community here and the unity among the community and the type of programs you guys do. And so I was really honored to be part of organizing this, and I hope we get to organize a lot of these. You will definitely be hearing and seeing more of me, whether you like it or not. So, our first topic today, after Brother Naushad's talk, dives into the Islamic perspective on will and inheritance planning, which will hopefully lay a good foundation for all the financial and legal aspects that we'll cover as well. We are very fortunate to have Maulana Farhat Abbas to guide us through the key Islamic principles and principles around wasiyah, distribution of assets, and how we can ensure that our plans are aligned with our faith. Please recite a salawat as we invite the Maulana to come back to the stage. Is it on?
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم وبه نستعين وهو خير ناصر ومعين. Assalamu alaikum wa rahmatullah. Well, thank you very much for coming for this workshop. Can you hear me? Can I use the other one? Is it better? It's better now? All right, alhamdulillah. Well, thank you very much for coming for this workshop. It's very important. Like as brother mentioned, wasiyat is one of the most important things that will remind one of the important pillar, which is ma'ad. I mentioned in my speeches so many times that Amirul Momineen, like here, I don't know, once a while we talk about death. Amirul Momineen used to talk about the death every day. It's narrated that when he was leading the Salat in Masjid Kufa, after Salat Isha, he used to come outside and with a loud sound, he invite people that, oh people, prepare yourself for death. And writing wasiyat is one of the preparation. Now, again, let me just go directly to this Islamic will or Islamic wasiyat. It's a deep topic. I already created presentation, inshallah, for other time through like the book of Marajes in depth, which take, I don't know, maybe 6 to 8 hours presentations. So right now I'm just going to cover the basic part, and then another time we'll go deep dive in Islamic will. Now, first of all, let me explain Islamic will is different than the law of inheritance. In Islamic will, we are not talking about ahkam of inheritance. You can mention in Islamic will, but you don't need to. Even if someone is not writing a will, the Islamic laws of inheritance apply. It's not that someone will say, well, this person did not wrote his will, that's why his inheritance has a problem. No. If it's a Sharia law, Islamic law, inheritance goes as per Quranic principle. No one has the right to change those laws except getting a permission from Wurasa. If all the Wurasa, all the inheritors, they agree, then you can change the proportion. Okay, this portion I'm changing it. Otherwise, when I was going through this Minhajus Salihin, which is a in-depth Arabic book of Ayatollah Sistani, nowhere he mentioned about Irs. Because again, that Irs is another chapter. Kitabul Wasiya did not have anything about Irs. This is Kitabul Wasiya is only, the Islamic will is only about 1/3 of your estate asset. That's it. That's 2/3 covered by Islamic Irs law. Okay? You in your Wasiya, you can mention some of those things, but even if you forget to mention, that will go by default as per Quran and the teaching of Ahlul Bayt. All right? So that's again as per Sharia. I'm not talking about the legal. Legal over here, it's different. Maybe the legal, they probably will say, well, you need to write down who will get what. But as per Sharia, that's already defined. So I will go discuss about the Islamic law. Let's see. Let me go through because time is less. Again, Wasiya Islamic will is when a person instruct that after his death, not in his life, that cover in another topic which is called hiba, right? No, if someone instructs someone that after his death, certain act be carried out for him, or he says that after his death, a part of his property will belongs to someone, or he appoints a guardian for his children. That's all these things cover under Islamic will or wasiyat. All right? So inshallah, let's go through the key terminology of wasiyah. The person who is making or writing the will, that person is called in Arabic musi. That will or the subject, for example, that property or estate, that called musabih. And then beneficiary in Islamic terminology called musaleh. And executor is wasi. And then that thulth, 1/3, that maximum portion of a musi, that person who's writing a wasiyat, may allocate outside irs. Again, you can change that, but you have to get permission from all of those heirs. Like for example, if I have 3 children and I have to change that amount, I can get the permission from them. If they agree, then I can change. Otherwise, Sharia does not allow you to change that. All those movie talk that I'm going to ask you, that's in movie. Okay? Not in real life. You cannot say, oh, I'm making you act. What is this, act? Yeah, there are a few conditions where a person can become, you can disown him. That's when Only one case I can mention. There are two cases. One of them, that person, your child, will become kafir, or that son will kill his father. These are the two main cases where you can go on that dialogue of movies. Otherwise, there is no such thing as, all right, I'm making you ark. All right? Now, so these are the terminology. Let's go to the next one. Definition of wasiya. Instructions to be performed after death. Acts on behalf of deceased, transfer of property, appointment of guardians for children. Now, there are three, all right, forms of the will. Wasiyat. Now, in the legal term, you need to write down something. But in Shariat, and that will apply, if either can by speech, you verbally state this something, verbally say that I'm doing this wasiyat, that this 1/3 or part of that 1/3 I'm giving to my cousin Zaid through speech. By writing, again I'm talking about Shariat. Legal is different. Legal you need to have something, and sister will explain the legal part. I'm just talking about the Shariat. Your Shari wasiyat, even if you just say to someone and your Warasa, they understand, the people around you, they understand, that's valid. Even by gesture, let's say, you can say, this horse I'm giving to this cousin. All right? Even through gesture, the wasiyat is valid. Again, Shariat. Must be clear in common understanding, which is urf. All right? Types of will. We have tamlikiya wa ahdiya. The one where, again, I'm keep reminding you, I'm just talking about that thulth, 1/3. You can, if you have the wasi'ah, where you're saying, for example, in endowment case, this part need to go to IC. That will come for this category, the first one, where you are making someone, I will discuss this more, you're assigning that assets to someone. And again, you also have, other one is ahdiya, which is directive will. You have giving a direction in the wasiyat. And the third one, which is no longer apply, but still fuqaha, they write, let's say after me, free that person, that will become the third kind. All right, the first one. The property or rights are transferred after death. Which means, example is, that guy, testator or musi, makes a will that part of his property or religious or shari'i right should belongs to someone, and again that musi, again remember that the one who's making the will, he is assigning a musaleh, someone, a beneficiary. Beneficiary is that person, after my death, these assets will go to this, as long as that's under 1/3. I will discuss this later on. If it's more than 1/3, is it valid or not? We'll discuss this later on, inshallah. So again, for this kind of a wasiyat, you need to have musi, the one who is writing the will, musabih, which is the asset. For example, this house, these stocks, this insurance, that's all of them will become that estate, which is Musa Bey, and Musaleh, which is IC endowment fund, or my cousin Zaid. And sometime wasi, sometime it's not necessarily that you need to have an executor at that time. Executor could be appointed later on. In some cases, there is no executor. All right, so the next is rules of when you make this tamlikiya. Tamlikiya, by the way, is from milk, milkiyat. you're making this to someone's milkiyat, someone's, like, okay, that's after my death, you will get this. When you're writing, let's say I'm writing like this will, where I'm giving these assets to IC endowment. Does it require that wasiyat, in order to wasiyat to be valid, again, I'm not talking about the legal part, I'm talking about the shari part. Does it require that someone from the endowment committee will be there and says, all right, I'm accepting it? Is that for validity of this wasiyat, does it require? It says no. Validity of will does not depend on acceptance. Okay? For example, I'm saying that this horse after my death will go to Zaid, one of my cousin. Right? So Zaid is not accepting, is not there to accept, but is my wasiyat is valid or not? It's valid. It's valid. My wasiyat is valid. Now, ownership, now who, after my death, they will go to the Zaid and say, Zaid, this person left a horse for you. If you hold that and says, all right, that's it, ownership established. If he says, no, I don't need that horse, this will come back to my estate and will go to my inheritors. These people will get it. All right? So again, this is an important point. When you're making a will, validity of that will, as per Sharia law, legal is different, maybe. I'll hear from the legal experts. Shari'an, that will is valid. Okay? And then whenever later on that person will accept that, then again that will be that he will take the possession of that. All right, so that's the key point here. Now, this beneficiary is something else. Let's say, again, because I'm talking about this, and let me go talk more than about endowment, because I'm talking about wasiyat. Let's say I'll say that this horse of mine will go to Zaid. Or let's say horse is not very common these days. All right, from $10,000 from my assets will go to my cousin Zaid. And you know that cousins, they do not get inheritance like Islamically, right? Let me go through this irs first of all. Let me go back to the irs ahkam. How many of you know who receive your irs? Raise your hand. Or if you do not know, raise your hand. Because majority of you know. All right. Who are your warasa? Right? What's the group? Anyone? Is your uncle, is your waris? Huh? All right. So there are several warasa, but they have grouping, right? If the first group is there, it will never reach to the next group. The first group is your children, your parents, and your wife or spouse. All right? Again, warasa is actually your parents and your children. Wife inherit something. That's the first group. Even if there is a single person exists in this group, parents and the children, I'm not talking about the wife or spouse, parents and the children, inheritance will never reach to the second group. Who are in the second group? Siblings. Siblings, right? Siblings. Okay? Now, that's the next group. If there is, let's say, you do not have parents, you do not have children, you do not have sibling, who are next? Then your uncles. Okay? Then your uncles. If anyone, one person exists in the second group, that inheritance is not going to go to the third group. Okay? They're not going to get anything. Right? So that's why when I was talking about the Zaid, who's my cousin, he's not going to get inheritance from me. But he is poor. I feel for him. let's say he is sick and he have young children. So I said, all right, after me, $10,000 need to give into the Zaid. Now what about this? If I made him beneficiary for my will, what about if Zaid die before my death? Because this wasiyat will implement after my death. What about Zaid will die before me? Well, let's say he died, and after 5 minutes I died. Okay? Now you have this wasiyat in front of you. Okay? That again it says that Zaid need to inheritance that $10,000. Right? But Zaid died before me. And then I died. My wasiyat is still valid. What will happen? If that Zaid has inheritors, okay, this is when I talk about here, the heirs of the beneficiary inherit rights to accept or reject. Again, the same thing. Beneficiary had the right to accept or reject. Remember that when I said Zaid, I can give my $10,000 to Zaid, Zaid had the right to accept or reject, right? When he accepts, that's fine. The same thing with his inheritors, all right? So that's again another thing. If I somewhere mention, no, it's only for the Zaid, not for the children, then it will come back to my estate and they have to distribute it accordingly. All right. Let's say time check. How many minutes I have? All right. Now the second one is directive will, ahdiya, where you're giving a direction. Will that action be performed on your behalf? Your burial. If you have Hajj, you did not perform Hajj. If you have qaza prayers, qaza fast. So there, there's no personal beneficiary. Here you have directive. And you assign someone and say that perform from my assets, perform the Hajj on my behalf. Or take care of these affairs of mine. Like I give you this is so important. Let's say if I had a debt, I owe something, I can assign someone that after my death, make sure to pay that person. These affairs are so important. Remember that when Prophet migrated from Mecca to Medina, right? Prophet had some trust, amanat. What Prophet did? Why Amirul Mu'mineen and Fatimiyun? By the way, there were 3 Fatima, they came with Imam Ali, right? 3 Fatimas they came. So, Prophet, he instructed Imam Ali that you be my wasi and hand over these amanat to kuffar. This is important. And that's exactly what Imam Ali did. All right? So this is an important thing. We have to make sure. Again, I'm going really fast. I told you another time I'll go through in depth. That require at least 6 to 8 hours presentation. Okay? I'll go through this later on. Okay, I'm skipping this one. This is like if someone said after my death, make that slave free. That's something else. Now question, when making you know that making a will is not obligatory. When making a will become obligatory? If you have missed prayers, if you have missed fast, khums, zakat, kafara, debt, obligatory hajj, and there are a few other affairs, like say children are young and you need to appoint a guardian for the minor children. There, you're making a wasiyat, making a will become obligatory. You have to make a will now. All right, now everything has a condition in Islam. The one who's making a will, there are conditions for that, shar'an. The person who's making a will, which is musi, must be sane and mature, aqil and baligh. Again, he must make the will with his free will, not someone is forcing that person. It's not like someone is putting a gun on someone and says, make a will. No, that will is not valid. That will is not valid. Need to be with free will. He must not be legally barred, mahjur. For example, some people, they are financially not savvy, they are safi, they cannot make financial transaction. And there are a few other, they cannot. So that persons need to be financially sane, he can make the will. And again, there are several other conditions which I'm not discussing. Even like if mumayyaz child, like a 10 years old child, they have a limited area where they can do wasiyat. For example, if he owns something, he can do it for the charitable things. These are the conditions for musi. Now, condition of beneficiary, right? Again, I did not include that. Like, for example, organization. Endowment is a very noble cause. Remember that we always talk about the best amal, afzalul amal is what? Intizarul faraj, which means you're preparing yourself for the reappearance of Imam. When you support an Islamic organization, and especially those organizations, they can prepare a groundwork for the reappearance of Imam. Actually, you're contributing for this. Okay? So that's included. Conditions of beneficiary, it's for the people, like for example, I'm talking about the Zaid. So that Zaid must need to be, can be alive or even in the womb at will time. Like someone, let's say my niece, she's pregnant, I'll say I like to go and make a beneficiary from that child later on, I can do that. But again, if unborn, must be born alive. And again, it should not like give up Islam. Again, these are all chapters. What are the conditions of something like this musabeh, which is that asset which you need to donate, or you writing a will about this? Property must be transferable. I think that we need to discuss more if we have to with connection with the endowment. Which things, what thing you can like write down in your Islamic will. The property must be transferable. Must have lawful benefit. So again, so the property or right must be transferable, which means it's a physical object and, or it's like someone borrows something from me, it's a debt. Or a benefit, manfiat. For example, I have a garden of the fruit and I'll say, look, the fruits which will come, I'm donating that for this organization or for this person. So again, these are the conditions of what you can donate or what you can put in your inheritance. Again, transferable, lawful benefits, lawful or rationally recognized benefit. For example, someone who has the legal right to obtain a housing loan from a bank, but under the regulation cannot transfer that right to others, cannot make a will that after his death, this right be transferred to his brother, child, or anyone else. All right, this is very complicated. I'm not going into this one. Future assets may be included. Act must be shari, not foolish, not sinful. It's not that someone will say that, look, I'm writing a will that after my death, go and knock on the 7 people's houses, right? That's foolish, right? You're not supposed to write down wasiyat like this, okay? So these are the conditions about which you can write down your wasiyah. Now, condition of executor. If you have executor, must be Muslim, mature, sane, and trustworthy. Executor is a trustee liable only with negligence, cannot withdraw unless the musi intended flexibility. Can you have multiple executor? Yes. Maybe independent or joint. Independent, each may act alone. Joint must agree together. If you make like 2 people as an executor, they are joint about your house, then you must agree. If you make 1 executor for your house, other executor for your stocks, they are working independently. And again, if there is a dispute between executors, it needs to be resolved by Hakim Shar. Replacement appointed by Hakim if needed. That's about executor. Order of implementation, financial obligation from the main estate. All right, this is important. Let me just spend few minutes over here. So the order of implementation will be such, depending on what the will's concerned, one must proceed following. If you have any debts, if you have homes, zakat, wrongfully acquired items, which mean mazalim and kafara, that need to be taken out first from your estate, from your whole estate. Okay, this person may write down that, okay, you can pay that from my 1/3. You can also do that. If he didn't mention that these mazalim, this hajj need to be out from my 1/3, then it will be taken out from the whole estate, and then they will do 1/3 again, okay? So again, there is a difference between these two. What happened? Got disconnected? Oh, I didn't realize that I'm moving my side and I'm not moving that. These guys, you guys are moving? Okay, I'm sorry. Thank you. All right, let's go back to this 1/3 calculation. Right. So again, you need to calculate the 1/3 from the remaining estate. In Islam, there is one other thing called diya. Let's say I am Musi, I wrote my will, and I got killed by an accident in an Islamic country. That diya will come for me, that will be part of my estate, okay? Like life insurance and other things as well, right? So that will also be calculated. Property may be designated as 1/3 portion, all right? Again, it's a long discussion. We'll discuss that another time. All right, next one, example. Let's say after all these obligations, after everything, whatever the estate is, it's $200,000 from my estate. 5 more minutes. So let's say I wrote in my will that I'm giving like $200,000 to IEC. After giving all mazalim and everything, I realize now my estate value is $600,000. And from there, the debt come out was $100,000, remaining was $500,000. 1/3 of that is 166,666, which is less than which I wrote the will. There are only two options. One option is that will change with this 1666 and this one, right? Or they have to get the permission from inheritors, right? They need to go to my children and they says, well, are you giving a permission? Your father, he mentioned he donated 200,000. That was more than 1/3. It's coming out from your share. If they agree, then that's fine. All right, this is an example. All right, when someone, let's say I wrote a will, I am the Musi, if I will die, can anyone change my will after my death? No, it's not permissible. It's not permissible. And again, even the Wurasa, they cannot change it. And anyone, whoever is changing it, that person is liable. All right, if there is a ambiguous will, if a minimum certain amount exists, carry out, that example is unclear, if it's $2,000 or $3,000, which one you will use? The minimum one. If there is a ambiguity about, like let's say I wrote something and it's not clear, and you think it's maybe 2,000 or 3,000, you go for the lower amount. And after the death of that person who wrote the will, if it was unclear, if that beneficiary, it was poor or Sayyid, then I will find out a poor Sayyid, not just a poor person, not just the Sayyid, I'll find out the poor Sayyid. All right, let me just finish because my time is up. If you have multiple wills, the earlier one have priority unless otherwise stated. Financial obligation, main estate, bodily obligations, 1/3, voluntarily 1/3. All right, I'm finishing, my time is up. Again, I mentioned already this, that if it's beyond than 1/3, then you need to take a permission. All right, proving a will, guardianships, two just men, they will come forward and they says, yeah, that's the will of your father, he died. Or maybe one just man and oath, someone take an oath. Or just man and two just ladies. And again, at the same time, all the Wurasa, they accept this. Revoking or doubt, again, if the Musi, the person who wrote the will, is still alive, he can change, he can revoke any time before death. And a revocation may be verbal or by action. Doubt is unconditional will, assume not, revoked. Conditional will invalid if conditions not met. All right, I'm sorry I went real fast, but inshallah, as I promised, next time, whenever there is a time, we'll go through, dive in this presentation in depth. Thank you very much, inshallah. As I mentioned, this endowment fund is a noble cause, inshallah. I hope that majority of you will participate, inshallah. Please recite a loud salawat.
Jazakallah Maulana for that thoughtful perspective. While we're doing that, a couple of quick announcements. We will be providing slides. The slides that are presented today, we'll be providing most of these slides to you after the presentation. So please, as I'd mentioned before, if you haven't put in your information, your email address, your name and number, please do so. There's a QR code at the table in front that you could scan in through your phone and enter your information. We have this book, Writing an Islamic Will. This is by Maulana Sayyid Muhammad Rizvi. It's got really good information, examples, and the like. that would be a good guide to have with you as you're thinking about your will. We have some copies available. We do request a $10 donation if you do want to pick up one of these books. And then finally, after this next session, we'll take a quick break, a short break for chai and restrooms if anyone needs to. Okay. Next, we'll turn to the legal side of estate planning, how to ensure that your will is valid, your wishes are properly documented, and your family is protected under the law. We're joined by Sister Sidra, an experienced estate planning lawyer who will walk us through the essential components of wills, trusts, powers of attorney, and how to navigate the legal system in the U.S.
That would help. Hello? Yes. Can you hear me? Can you hear me? Switch it. Is this better? Okay. Okay. Do we have the slides ready? Okay. Assalamu alaikum. Bismillahirrahmanirrahim. Thank you so much, Maulana Farhad Abbas, for that very informative talk. That was a lot of information that I didn't know, so I took about 2 pages of notes. It was very informative. Thank you to Islamic Education Center, the Endowment Fund Committee for hosting this event, and Brother Ali Danji for inviting me to speak alongside him on this really important topic. So today's topic is basic estate planning. Why it's important to have a will or trust. I know I'm actually really proud of this community. MashaAllah, the turnout is so, it's such a good turnout. I know that there are still people out there who don't really want to talk, like the earlier brother, the first brother who spoke said that they don't really want to talk about this topic. There's almost an irrational fear about bringing up the topic of death and having an open conversation with our family members about it, that if we talk about it, maybe it'll happen sooner, or that, you know, even bringing it up to our elderly parents, we fear we may disrespect them by bringing it up. But it's important to have these types of conversations so that we can be more aware about what our religious obligations are, alongside what, you know, the rules of Texas allow for inheritance and passing our inheritance. I actually had a call just a couple days ago from someone who was looking for some information, and he had asked a question. He had a special needs child, and he had asked a question about estate planning, and he said, I don't actually believe in wills, but I fear that, you know, we had a lawyer come to our masjid, and he said that our estate will be taken away from the government if we don't have a will or trust. So I think that doesn't happen. There's still a lot of misunderstandings out there. So it's great that we have these kind of talks. So basics of estate planning, why is it important to have a will or trust? Can anybody tell me what they understand estate planning to be? Like, what is an estate? An estate plan? Your assets, your home. Financial accounts, right? Anybody else? Okay, so, well, an estate is essentially that all of the assets that you have acquired during your life, assets meaning bank accounts, your home, investment accounts, let's say legally retirement accounts, insurance, life insurance, all of these, even your property in your home, those are all of your assets minus your debts. That is basically what your estate is. So then when we're talking about estate planning, we're talking about a plan for those assets. We make the plan, a written plan for the distribution of those assets, and then we assign a party, an executor or trustee, and I'll go more into detail about what those terms mean. But to wrap up your affairs, affairs of the decedent. Decedent is the legal term for the person who's passed away. To manage the decedent's property during the wrap-up period. So that is, if you have a mortgage ongoing, or if you pass away and you leave a spouse and children, they're living in your home. You want to keep that home up to date on your payments for as far as property tax goes, paying the bills. The executor would be in charge of maintaining that until the point where it's ready for distribution to the intended beneficiaries. So that is basic estate planning. And when you hear an estate planning attorney, they say we do estate planning, they're helping set up a plan like this. All right, so last will and testament. That is the mechanism used to transfer your assets. And I think a lot of people, everybody has heard of what a will is. Last will and testament is just a fancy way of saying will. It is probably from old British term that's used. You don't actually need to use those terms for it to be a valid will. I did have one client who wanted this heading on their will. I had sent him my draft. It said will of so-and-so, and they made me edit it to say last will and testament. But I guess it's personal choice. But to have a will, you need to identify the testator. So testator is the person who is writing the will. So you are identifying, naming yourself, which county you're from. It must be written with testamentary intent, which means that you are saying that this is my intention to distribute my assets when I pass away. If you have a list of your assets, your home, bank account, a horse, I guess, that could, whatever it is, and you say you want your mom, a list of assets, and then maybe an arrow that says mom, son, daughter, for bank account, that is not sufficient testamentary intent for the transfer of your assets legally. I think Islamically, we just heard that a gesture is enough, but legally it would not be sufficient for a legal obligation to transfer that asset. So identification of the testator, testamentary intent, saying in there that this is my will, my intention is to distribute my assets this way, and then the capacity to execute your will. So you have to be over 18 and of sound mind. Again, identity, testamentary intent, and then capacity. If you don't have those three things, you don't have someone who's you don't have a valid will. And you have to follow the formalities of the state in which you reside. So in Texas, the formalities include 2 witnesses. They have to be over 14. They have to actually witness the signing of the will. If they are not there during the signing, then it doesn't count as a valid will. I had one case, a client came to me and for probate, and they had, the witnesses had signed the will, but the dates of the witnesses were different. So there was no proof that they had actually witnessed the testator on this date. And what we had to do to fix that situation in court was that to show that there were 2 witnesses, we had to use the notary that was there as the second witness. So that is required. And then a signature is required. These are very, very basic information, but people tend to forget that these are required, or they make a simple mistake. If you're downloading, an online form, or you pick up, a will from whatever local community center, if they offer it, these are some of the mistakes that we as probate lawyers, we see happen often. There was one case where there was no signature at the end. They had initialed each page on the will, but there was no signature on the signature line. They had forgotten. The way that we fixed that issue was by saying that the initial was the actual signature of the testator. So it was, each page was labeled 1 of 6, 2 of 6, 3 of 6. So we were able to say, well, he actually intended this to be the entire document, and his initials count as signature. But the point is that we need to try to avoid those mistakes when we're creating the will, so that there's no problems down the line. Okay, so some of the The formalities were not followed, as I had mentioned these last two examples. The executor named in the will is unavailable or not willing to serve, and that again comes with open communication with your family members. You want to make sure that you are assigning somebody who is willing to take on this duty, because it is a lot of work. It's gathering your assets, it's making sure that the correct distribution goes out, and then taking it to probate court. So you do need to make sure they are willing. And then it's the more often case is that they have predeceased the testator, so they aren't available. Again, another issue that we can solve in court, but the hope is to do it with minimum, fees, minimum time to have it done correctly the first time. So that is why it's important to talk to someone who is familiar with the laws and just being aware of the laws in itself. Disinheriting heir, that has happened when you have created, I know the earlier brother had mentioned that he made his will 40 years ago. In that time, did you get remarried? Did you have more children? And if you don't have a definition of children in the will, if you don't have, maybe you named specifically who receives it, in the will itself, legally speaking, if they're not written there and there's no definition of the class, then they will unintentionally be disinherited. I have seen that happen. Lost will. I had a client who had come in for a probate of their father's estate, and they knew that their father had at some point created a will, but they did not know where it was located. They looked everywhere. They looked in the safe deposit box, and in their files. They couldn't find it. In the end, they ended up talking to the attorney who created it. The attorney had a copy of the will, but did not have a copy of the will signed. So it did not count as a valid will, and they had to proceed in probate court without a will. And then possible will contest. So we had talked about of sound mind when you're creating it. There are issues. You see this often when there may be an elderly person. Maybe not often, but at least I know some colleagues have seen this happen where the mother has signed off all of their estate to just one of their sons, or maybe a caretaker, and then that's what happens in a will contest. Someone says, well, they did not have sound mind. To address that issue, attorneys have often videotaped the signing of the will, just to ensure that there is capacity, that the person knew what they were doing, that they had capacity, and they were of sound mind when they signed the will. Okay, so I mentioned probate a bunch of times. I think that this is where people get a little bit confused. When you have a will, it's a two-step process. You have a will, and then you have to go through probate court with that will. It's required. It is not, the terms of the will are not enforceable until you go through probate court. This is what a probate court looks like. The judges are very kind. It's a very quick 10-minute hearing if you have a will. If you don't have a will, it's a lot more complicated. It takes a lot longer. But it is, the judges understand that you're there. This is generally the first time anyone's ever been inside of a courtroom before. And so they are very understanding, and it's not a difficult process. You go through the process. You have named an executor in the will. The executor receives letters testamentary, which is a court official document that allows for the executor, it just validates the will and allows for the executor to say he is named in the will and he's able to go into your accounts. So you have a house that needs to be transferred. You have bank accounts that need to be transferred. You now have somebody who has the authority through the courts to be able to go into the bank, the investment accounts, and state that they have authority to enter and remove those assets from those institutions. So probate, you have also notice to creditors. When you probate a will, there is official notice that all of your creditors will receive. So everybody finds out you pass away. The creditors often have a database that they look into, and they are able to see which wills are being probated, and then they have time to file a claim against the person creating the will. again, it is public record, so it will be filed with the state. When you go and probate a will, it's available to basically anybody to see what you've written in your will, who your beneficiaries are, and then also your inventory of your assets. So everything that you own, you have to file with the court a list of all of your assets in court, and so it is public record. So what do we do to avoid the public record? Anybody? A trust. Yes. Revocable living trust. And is the number one reason why people come to me asking me to create a trust is to avoid probate. The formal definition of a trust. Trust is another mechanism that you can use to transfer your assets other than the will. It works very similarly to the will, where you are assigning somebody. In a will, it's the executor. In a trust, it's the trustee. So it is a written contract. It's where one person, usually there are different names for it, settlor, grantor, trustor. Let's say grantor, that person who owns the assets is the grantor. They write a contract and they name a second person who is the trustee to manage the assets. It can actually be the grantor himself, and then when the grantor passes away, he names someone else. And then the trustee is responsible for managing and distributing the assets according to the trust terms. So there's three parties: the person creating the trust, the person who's in charge of managing the trust, and then the beneficiaries of the trust. So you can have a trust. You can have it for management of your property during your lifetime. There is a lot of upkeep. Like, you have to be able to transfer your assets during your lifetime. It can be created for any legal purpose. If you want your family members to have, we can always have co-trustees, and if you want them to manage different assets, you can name that in a trust. There's no formalization process of the trust. It does not have to be recorded anywhere. You don't have to provide a copy of it to the state, unlike the will. And then beneficiaries can be anybody. It can be the endowment fund. It can be, and I mean, of course, that is legal again. Islamically, you can include Islamic beneficiaries and the percentages that you believe the Islamic beneficiaries should receive. The nice thing about a trust is that you can give the trustee direction to consult an imam or a sheikh or someone who is familiar with Islamic Sharia distribution that would be able to kind of guide your trustee and make sure that all of your assets that are in this trust can be distributed out Islamically. Okay, so do I need a revocable living trust? The cartoon, it says I need to go back in time, change my family trust plan, and I told you not to give $5 million to a teenager. It's a possibility that we don't know what is written for us, but if you pass away and you have someone who has turned 18 is the age of majority in Texas. When you are 18, you're an adult, you're legally able to handle your funds. Do we trust an 18-year-old with a large life insurance policy or whatever assets that you have to be able to manage that? I don't think so. I often say that if your child is in college, if they have the money, what will stop them from buying, a Ferrari or something instead of a reasonable car, or buying a home that they don't plan on living in, or maybe even investing in a business that may not make financial sense. So a trust is a good way. So if you have it in a will that your children receive, they receive outright. If you have a trust, you can write into the terms of the trust the age for distribution. And you can also write in specific distributions. This is something you can write into the will as well. But if you have a lot of property, like you have jewelry or you have watches or you have art pieces, and you know that specific kids would really want to have this item, then you can write that directly into the trust. You can do it in the will as well, but maybe you can write in what age they would receive it. Or that you can also, the flexibility of a trust, you can write into the terms what the siblings together can decide on who receives what. So you can write that in. The plan for minors, again, You can say that maybe at 25, they've graduated from college, and now they are responsible enough to become a co-trustee. So they should be able to withdraw funds from the trust fund. And so you become they can become co-trustees at 25. They can now work with the other trustee that you've named in the trust to be able to distribute out those assets to themselves. But with some direction. And then you can write in at what age that they would become sole trustee of their own trust. Creditor protection, the reason why we may want a trust rather than giving it outright to our 18-year-old or 25-year-old, it won't protect you as the grantor of the trust because it is revocable living trust. It's still in your hands. We're not going to talk about irrevocable trust just because it's of the time constraints, but the revocable living trust does not provide for creditor protection. It will provide for protection to your beneficiaries. So if your child gets married, we haven't talked about community property, separate property rights, but in Texas, it is a community property state. So everything that you own and acquire during marriage is considered community property. And if your child gets married and they decide they receive their trust fund, they decide to withdraw it from the trust and just commingle it with their spouse's assets, like they open up a bank account, then it does become subject to divorce, or if they're being sued for whatever reason, if they're in a business and they're being sued, creditors wouldn't be able to reach those assets that are in a trust. They would only be able to reach the assets that are in their own hands. And a creditor including a potential divorce situation. Okay, and then revocable living trusts are good for incapacity planning as well. So if you are getting to the age where you feel that you may be entering stages of dementia, maybe, or in the situation where you may get into a car accident and you're unable to make decisions for yourself, you have the ability to name the trustee during your life when you have capacity to be able to use the funds for incapacity planning. So to take care of you, you have that trust, you don't have to go through guardianship. I had a client who wanted to make sure that they were not put into a nursing care home. So they wrote into their trust terms that all of the funds, that all of my assets should be used for in-home nursing care rather than a nursing home or something like that. So that's you can direct your trustee to use your assets in case of incapacity. And then again, privacy concerns, we talked about that, and out-of-state property. We were talking about people who live out of state. Maybe you have a home that you decided that you wanted to rent out because you've moved to Houston. You own that home in another state. Now that house, any home that is located outside of Texas has to go through probate proceeding to be transferred over to your heirs. And so now you're looking at, if you don't have a trust here, you have a will, you're going through probate in Texas, you'll also have to go through probate in that other state. So what people do is they will transfer it into a trust or an LLC and try to avoid that additional probate proceeding. Okay, and so guardianship, I'll go over that really quickly because you may think it doesn't apply to you, but in the situation that it does, trust would be a good way to avoid a full-blown guardianship proceeding in probate court. Guardianship is, most people when they think of guardianship, they think of guardianship of their children, or minors. But really, it can be, for incapacity, it's just the legal process that assigns someone to be able to make decisions for you in case of incapacity, and incapacity including a minor age. If you, for probate, we had letters testamentary. For guardianship, you have letters of administration, or letters of guardianship. Those are the official court-stamped document that says that you have the ability to go into the accounts of somebody who is incapacitated and make the decisions for them. This can also be, I mean, as you get older, you're reaching an age where you may not be able to make good financial decisions for yourself, and you feel, okay, I feel that I may get scammed out of something, or I want to avoid being tricked into giving away my assets. You can then give away your rights. A financial power of attorney can also do something like that for you. But when it is required is when you have minor children. If your parents pass away and you have children who are under 18, you would have to go through guardianship court. And then if you, in the case of disability, like I had mentioned, cognitive decline, like if you are reaching maybe the age of dementia, mental health, or an injury, if you're in a car accident and you can't make decisions, you have to go through the guardianship process. But the guardianship process in Texas is a two-step process. It's guardianship of the person and guardianship of the estate. The guardianship of the person is the person who will take you in, who will make all your daily decisions for you, who gets to decide who gets to visit you. Guardianship of the estate is who gets to take care of your finances. If you have a trust, you don't have to go through the guardianship of the estate, and that's when guardianship of the estate, you have to report back to the courts with annual accounting, what money is going where. You wouldn't need to do that if you have a trust. So people do prefer trust planning when they're talking about incapacity planning. Okay, so that was a lot of information. Wills, revocable living trusts, guardianship. That is the basic estate planning when we talk about basic estate planning. Documents that everybody should have, but you should also make sure that at any point when you're talking to somebody about estate planning that you have your supplemental documents. You have the medical power of attorney and you have a financial power of attorney. Those documents, I had another person come a few years ago whose father had a stroke, and he had to make some financial decisions, and the person who called me, his son had said, can I get a power of attorney? And it was too late to create a power of attorney because the father was not able to understand what he was signing at the time. And it is often when we think of these documents that it's in those situations where you need it. So it's good to think of them ahead of time and have them in the case that you need them. HIPAA releases all of your children who would be able, or whoever it is that you would want access to your medical records, and then appointment of agent for disposition of remains. Recently, I heard a story about a Muslim brother. He was a convert, and his mother had cremated his remains, and I guess they just didn't know that cremation was not allowed. And if you had this document, you would be able to appoint somebody. You would be able to say that this is the person who is responsible for my funeral arrangements. We try to do the janaza as quick as possible. So sometimes this document doesn't even apply. But if, for whatever reason, if you pass away overseas, if the funeral home is holding your remains, in order to avoid, cremation, and to have a specific Islamic plan written out for your funeral arrangements, this is the document that we would use. And then we talked about guardianship, and then advance directive is the physician, is the notice. It's the document that is a little bit more specific than the medical power of attorney. The advance directive will it's end of life care, whether or not you want to be on a ventilator, and it's a little bit more specific. So not everyone is required to have an advance directive, but if you have a specific idea of what you would like to happen, and a lot of times it's my older clients who want to do this, and they don't want to leave the instructions to their children to maybe fight over, to make an emotional decision at the time that this is happening, then they want the advance directive. Am I good on time? I think. Yeah? Okay. So you can actually have a trust written into your will if you wanted. If your purpose for creating a trust is to make it easier on your family, you want the easiest plan, you want everything to just 15 minutes? 10 minutes, okay. If you want it easier on your family, you want everything written out, you have specific instructions, you know who you, what assets want to be distributed how. It's better to have the revocable living trust. That is more of it's called inter vivos trust during life. Testamentary trust would be a trust written into the will, a contingent trust, which says that if I pass away and my children are under the age of whatever age you would like, 18, 21, 25, then at that point I would like my executor or trustee to create that trust for me. So you can write that language into a will if you want. Revocable living trust is usually what people go for, but you do have to remember that the trust document that you're creating is just paper unless it is funded, which means transferring your assets at the time that you create the trust into the trust, usually by transfer deeds or by beneficiary designations. And the trusts have a schedule of assets. Again, it's just paper, so as long as if you purchase future assets and you want to transfer them into the trust, you have to make sure that you deed, maybe you purchase a home, you have to make sure you deed the home into the trust at some point, or by beneficiary designation. The document that transfers a home into the trust at your death is called transfer on death deed. That is generally what I do for my clients. And then other considerations, gifting. I guess at all points it's important to talk to an imam and what is permissible in Islam. But if you are thinking about gifting, you should also talk to an accountant, because there can be some tax consequences of gifting, and I think maybe Brother Ali is going to get more into that. Discretionary waivers, again, talk to an imam or scholar and make sure that this is permissible. I think a certain class has to be able to waive. Everyone needs to be able to waive their right, but I know clients who want to avoid their brother inheriting. They would like their daughters to inherit before their brother in the situation where they feel that brothers would receive prior to their female children. They have written out waivers during their life saying that they understand that they're giving up their Islamic right to inheritance. Transfer deeds, I think we talked about that. Funding the trust is really important again. How to fund the trust is going through beneficiary designation forms through the companies. You would go directly to your bank and ask them for a beneficiary form. This is not something that lawyers typically do. They can help you with it, but to make it more cost efficient, you can do that yourself. Contact your institutions, your banks, your retirement accounts. Once you have a trust in place, you can just update your beneficiary forms with the trust. And then for any real estate, it would be the transfer deeds. Pour over will is, I think people don't realize when you have a trust, you still have the will. And that is just so, again, if you happen to move or happen to purchase an investment asset and you want to make sure that you are avoiding the probate process, if you're creating a trust, might as well do it correctly. You make sure that you have the will that says a very generic statement that just states that it is anything that is in your estate that wasn't transferred into the trust will transfer to the trust. Okay, I'm going to skip that one. It was just a slide on picking your trustee. It is one of the hardest parts of creating a trust is finding somebody who you would trust to be the person who manages your estate and distributes out, and they would have a continuous obligation to distribute it out to your trustees over time, or to your beneficiaries over time. So should I create a will, or should I create a trust? So the benefits of the will, simplicity, outright distribution. Your kids would receive whoever you label as your beneficiaries in the will, they would receive it outright. And it is more economical. Technically, mostly wills are probably half the cost of a trust. The disadvantages of a will is that you would have to go through probate, and then you don't really have control over your assets. After you pass away and you've assigned somebody to receive those assets, you can't now say that your beneficiary has to use these assets for sadaqah jariyah or whatever it is that you would want them to use it for. You can't really dictate what they can do with their inheritance in a will, but you can do that in a trust. Benefit of a trust is control over the assets. Again, you can state in there, if my child is not a Muslim when I pass away or does not identify as Muslim, then they will not inherit. You can write that in a trust. You can't write that into a will. centralized management, as long as you are transferring all of your assets into the trust, you still have that, the flexibility, as we mentioned, and the privacy. Disadvantages, it is upfront costs, and then finding a reliable trustee. Which one should you choose? I don't always advise everybody to create a trust. If your family situation, you're older, your children are older, they're not minors, you have a house, a bank account, and cars, and that is your estate, then maybe I will recommend just creating a will and maybe going through beneficiary designations to transfer those assets. It may not be right for your family. Every family situation is very different. Your family may look differently. You may be concerned about a child. If you could write into trust, like if hopefully we don't have that issue in our communities, but if they are an alcoholic or if they're going through whatever condition that you would want to write into the trust, if you don't want your child receiving it, then we would create a trust for you and your family. And then if you do need a more economical approach, the will would be the right answer. Trusts, again, I think we talked about it, but if you have minor children, and then if you want the flexibility of directing your trustee to transfer things according to Sharia, I think the trust is generally what I recommend for your family because of the ability to give the trustee discretion to be able to change the percentages and to talk to a scholar. Asset protection I'm not going to go into, but it is something that a lot of people come to me and have questions about. We talk about LLCs, we talk about homestead exemption. If you have a home, you don't necessarily need to transfer it into the trust, and I think everybody kind of gets confused about that. Like, I don't want to put my home into a trust, but you can still have the homestead exemption in a trust, but if your name is in there, you have that protection already. There are some federal protections for your retirement funds and life insurance and college savings plans. If anybody has more questions, they can contact me, but that is all I have for them. And thank you for the food and the chai. If I was talking kind of fast, it's probably because of the chai. It was very strong.
We'll do a quick 5-minute Q&A with Sister Sidra. So let's do this. Brother Mehdi has a microphone. And if you raise your hand, if you have a question, he'll bring it to you. You can ask a question. After this 5-minute Q&A, if there's other questions, please write them down and write down who the question is for, whether it's for Maulana, Sister Sidra, or Brother Ali Danji, who will be the next speaker, and bring them to the table. And at the end of the 3 sessions, we'll answer those questions as well. So please write those questions down. But for now, if you have a question, please raise your hand. Brother Mehdi will come to you.
Okay, I'll start. I have 2 simple questions. The first one is, as you mentioned, Texas is a community property state. So let's say if I own $600,000, the $300,000 is mine and $300,000 is my wife. And if I were to write will I write the will for the $300,000 that I own or the entire $600,000?
If you are, and this is only legally, not Islamically. Can you hear me? You can hear me? So legally, everything is 50-50. You are writing your will for the $300,000 that you own. And so if you are writing Sharia distribution into your will, and you write your spouse and your children and your parents, their value would come out of the $300,000, not the $600,000. So your spouse would be receiving the 50% plus the 12%. Plus the 12%.
Just make my family known about it, and they decide to amicably distribute the, okay. If I were to write a simple will and give it to my family and they amicably distribute it between themselves, among themselves, does the will still have to go through the probate court?
Yes, because your accounts, they won't have access to your accounts when you pass away unless you have letters testamentary. So they would have to, if they have a will, if your house is under your name, the deed has your name on it, they will, no mortgage, no lender, no title company will will sell your home. So say you pass away, your spouse wants to sell the house now. They can't sell it unless your name is off of the deed, and they can only do that through probate. Are you? If you have beneficiary designation, so the question was, if I have beneficiary designations, do I still have to go through probate? That's a very good question. You would not have to go through probate if you have a beneficiary designation under your bank accounts. But you also have to remember, with the beneficiary designations, how are you including everybody? If you're trying to do it Islamically, are you including all of your heirs? And what you don't really know your heirs until you pass away, like Maulana had mentioned. So it makes it a little bit more complicated, but you are definitely able to do it through beneficiary designation and avoiding probate that way.
I have a couple of clarifications, if you could do that. One is, what I understand is for this trust, the main interest is to avoid capital gain taxes. Is that true?
For the trust?
For example, for the house. So if you are in the will, when you're disposing of, you have to pay capital gain taxes.
So actually, the will would not, when you pass away, and if you have your house as an asset that you pass away at your death, then you have a step up in basis, and I think that's what you're talking about. And I think Ali's going to talk a little bit more about the step up in basis, but the value is taken at the date of death and not at the date that you purchased the home.
Okay.
So if you decide, and that's when you talk about gifting, if you're talking about gifting your home, you gift it now, then you wouldn't get that step up in basis. But if you are gifting it at your death, then you will receive that, the value would increase at the date of death rather than at the date you purchased the home.
Okay.
So you wouldn't have to pay those capital gains.
Okay, thank you. And my next clarification is, in the state of Texas, my understanding is that a handwritten will does not need any witnesses or notarization. Is that correct?
That's correct. It's called a holographic will. That is valid in Texas. If you handwrite your directions, sign it, you should make sure you include that you want your executor to be an independent executor, to serve without bond. There's some language in there that you have to make sure that you have it so that you can avoid those problems in probate court. But with a holographic will, it would be additional steps in probate court. So if you are really looking to create a will that's easy for your family, to make it the easiest, you want, in probate court, you want it to be a valid, like signed and witnessed will. If it is a handwritten will, it's still valid, it just takes additional steps to probate it.
So that has to be notarized if it's written.
No will has to be notarized to be a valid will. You actually only need the 2 witnesses and the signature, but again, having the notarization will make it self-proved in court, and so you don't have additional. It's the simple hearing that we're looking for. It would be a lot easier with the self-proof.
Thank you.
Thank you, Sister Sidra. We'll take a 5-minute break now, and the speakers, as I mentioned, will be available after all the sessions as well for further questions. There's fruit, cookies, and chai in the back. So please help yourself, and please be seated back again in 5 minutes. Thank you.
Yeah, for men's is there.
So for sisters here too.
This is the last one. If you want some more, we can, because unke paas tha nahi. You want one?
I'd like to get one, but I didn't want to grab the last one in case of
$10 is yours.
I tell it to you?
If you sell, then it becomes 20. It's a very well written book. We tried to get more, but he had only 17.
किसको दर करूं? IC treasurer कर दूं? IC treasurer किसको दर कर दूं?
बंदे को देना अलग से लेके आएगा you know how to buy
वॉलेट गाड़ी में छोड़ के आया हूँ लेके आऊँ
पहला वीडियो आराम से करना है ना कोई रखी हुई है तुम इसको गाड़ी में रख के आए और मैं $10 भी लेके आया ना पहले चाहे समोसा ले लो वरना वो मुझे नहीं करवा ये वो
बहुत लंबी लाइन है मैं लेके आता हूँ
यार ये कोई आदमी लेके आया उसको
कौन लेके आया
साहब लेके आए
कौन कौन हाँ
I will just give me the $10. I'll give it to him. What do you give it to him?
We have a book here. It's gone. It's gone. भाई क्या हाल चाल
बोल दिया गवर्नमेंट
खुल गया
अब लूटो
So I have to pay $10. So through Zelle, Zelle is accepted.
Zelle, yeah.
What's it? IC को नहीं है इसको देना IC ने nothing to do with that. You are the one who bought this. तो आपको अगर आप लेके जा रहे हैं तो आप
मैं इनको $10 दे
जी $10 अगर कैश है आपके पास
कैश तो नहीं है इसलिए मैं Zelle करना चाह रहा था
आप उनका
आपके
फोन नंबर दे रहे हैं आप उनको
फोन नंबर पे आपको कर दूँ या just hold a second. No, phone number बताएंगे? Yes, sir. Yeah, please give us phone number. 312-404-5273. And your name, are you?
We have this in the library. It's old, very old. Yeah, no, so old. How much are you charging to the library?
Check out.
Oh, it's a book.
312-404-567.
No.
Yeah,
So I'm taking
It's a
one.
donation. I have a PDF copy.
Oh, yeah. Maybe PDF is also available.
Yeah.
Actually, I usually had a.
I created that.
No, I have here.
When I created, I did all the graphical work on it, and Ashal Bhai was in the board. The problem was that for years it stayed dormant, and that software is no longer available, and no software can read it. So I cannot update it. I mean, I can do it, but it'll take work. I have to recreate all the drafts and show all the drafts.
I think Hassan was involved.
Can I please ask everyone to go ahead and take a seat, please? We want to start the next phase of the program. Please finish taking the snacks and come and have a seat. Thank you. Hello? Can I please ask everyone to come and take a seat? We're going to start the next phase of the program. Can I have your attention, please? One quick announcement. Today's presentation is being recorded and will be on YouTube. So if you need to watch it afterwards, it will be available. So if you don't feel like you need to write down everything or take pictures of the slides, you don't really need to. We'll provide you the materials and the presentation will be available. I'd like to invite Brother Ali Dhanji. Brother Ali Dhanji is the final speaker today, and he's going to connect everything from a financial planning perspective, everything to do with will and estate planning, tax and financial strategies around it. So please help me in welcoming Brother Ali Dhanji.
Hear me? Okay, I'm generally loud, so I'm sure you can hear me even without the speaker or microphone. Assalamu alaikum, everyone. I feel like a presenter who is the last presenter at lunchtime. So my job will be to keep you awake for a little bit and talk about the boring subject of financial management for estate planning. There is a lot to cover in the financial management side of things, so I will try to cover the basics of it. Everyone has an individual situation, so we can talk about individual situations later on or maybe in the Q&A. There is a lot that I don't know myself as well that I will be very upfront because every situation is different, every situation requires different level of complexity, but I will assure you that I will find the answers for you wherever you need it. So this is one of the topics that there are a lot of people make their mistakes in where people think that having a will is sufficient enough or drafting the legal document, and I think Sister Sidra touched upon it where the legal part of it, if you get it done, you think that majority of the work is done and I don't really need to do anything. But what people forget is that after making the will or the trust, you have to make sure the financial assets are appropriately transferred into the trust or the beneficiary designations are titled. There was one question on cost basis, which I will probably cover as well. And then the community, property versus common law as well. So we'll touch upon some of the basic topics over here, and then we can try and address some of the individual situations, or I can talk about it later on individually, talking about individual situations of answer. I don't say this is an important topic because I do it personally, professionally, as a financial advisor and wealth planner. But I say it because of my personal experiences. Those who have kids in high school or near high school age would probably associate it more. When I was in high school, or I just completed high school, in the space of 2 years, my elder brother, my grandfather, and my father passed away. In space of 2 years, all three of them breadwinners for the family. Knowing how traditionally moms are homemakers, my mom was a homemaker. I was a high school graduate going into college. I saw all the struggles that my mom had to go through to put together all of this. We had, again, I say it in my presentation that we had plans, but we did not have an estate plan. So that's the big difference where a lot of people have plans, but unfortunately we don't complete the estate plan that is needed to execute those plans. So I talk from my personal experience of having gone through those situations, and that's why I say this is probably one of the most important things you will do in your lifetime. Who knows Alfred Nobel? Anybody here? Alfred Nobel? Oh, well, a few of them. Okay, so Alfred Nobel's famous for what? Okay, so many people know him for Nobel Prize, but if you go back and look at the history of Alfred Nobel was the inventor of dynamite. Yes, many people don't know him. Why all of a sudden change from from making dynamite to Nobel Peace Prize? Miles apart, right? What happened in 1988, if you see the newspaper headline over here, the merchant of death is dead. He was one of the few privileged people who had the opportunity to read his own obituary when he was alive. The world remembered him as a merchant of death. When he read this while he was alive, and it was not him who died, it was actually his brother died, but the newspaper made a mistake. But he got to read his own obituary while he was alive. So when he read that he was being remembered as a merchant of death, that was a life-changing moment for him. He decided, at that time, his estate is sort of calculated to be around $270 million in 1888, which is in today's dollar value is almost $7.8 trillion. That was a life-changing moment. He decided to create an endowment fund which sort of supported the whole Nobel Peace Prize, which we now know. I don't know how much Nobel Peace it is, but keeping that aside, he did a good thing, at least, by donating his assets. So now it's a question on us whether we want to be remembered for the dynamite side of things or the endowment support or the legacy that we want to leave behind. It's a question that will define what we basically, will be defined by what we do. What I want you to remember is two things. One is, what is your net worth? And I will address it. When I talk about net worth, it's not the net worth which is basically only on your balance sheet, not just the assets and liabilities. Sorry. It is basically your net worth in terms of the legacy that you want to leave behind. The children, the etiquettes of your children, your ethical will side of things, your values, everything is part of your net worth. So we will talk about that later on as well. And then the second question is, what do you plan on leaving as inheritance? So some of the sort of things that I will cover have already been discussed. I'll brush upon them, and then we'll go through the presentation together. Now, what is an estate? We've already spoken about. If you have children or parents or family, and if you have assets and belongings or property, you have an estate. It doesn't matter what the value of it is. Even if a question was, if I have a $100 TV, can I create a trust for it? Yes, you can. You can spend $5,000 to put a $100 TV in the trust. It was a joke question, but I thought I would share. And I was asked to present an answer for that also on the stage, which I will not. So if you have an estate, you need an estate plan, because you need to make sure it goes in the right hands, it goes as per your wishes and what you wish for that asset to happen after you're not there, or if you're incapacitated. Estate plan, it helps you define what will happen with your assets, who gets your assets, when do they get the assets, and how do they get the assets. So you have a lot of control over the assets that you can distribute over your, sort of after you're passing away. Mainly people do estate planning, and sorry, my apologies for the slides are too busy, I understand, because I have to give the slides to you, so I wanted to make sure I put everything, so even in my absence, if you read it, it's my Savabajariya that you can benefit from it. So mainly people do estate planning for 4 reasons. One is, of course, the religious obligation. That is a big reason why people consider estate planning, to make sure that your religious obligations are fulfilled, khums, zakat, sadaqah, whatever, the reason may be. If you have debt that you owe to somebody, you need to, and we've briefly touched upon that as well. The second big reason is asset management or asset distribution. If you have assets, how would those assets be distributed in the most efficient way? Third is avoiding legal complications. We spoke about the probate court, of how the probate process works, and the difference between a legal and how to avoid the probate process. And the fourth is tax efficiency. Now, I'm not a CPA. I have some tax answers, not all the answers, but yes, we can find out the answers to your questions that need to be.
More importantly, it allows you to distribute what you have according to your wishes. That's what estate planning is all about. Now, when we spoke about estate planning is a three-legged stool, three-legged stool. People do one aspect of it, which is the legal aspect of it, to create a will or to create a trust, and then we spend a lot of time on what type of trust. But then what they forget is for the first part, which is the planning part of it, and then the third part, which is the execution of the estate plan. And that's where majority of the mistakes are made, and that's where a lot of estate plans become invalidated because they've just not been executed correctly. In terms of the planning phase of it, and I don't want to spend too much time on it, you simply have to create an inventory of what you have. Basically, all the assets that you have to list them down. Your bank accounts, financial accounts, investment accounts, real property, jewelry, et cetera, et cetera. Then you have to identify who gets what. Basically, who are you leaving behind to according to the Islamic principles? Of course, the 2/3 is a given, the 1/3 discretionary. You can decide what you want, or if you have the permission from the other 2/3, you basically make the decisions of it. But at least you need to know who gets what in what proportions. And then the third is what happens afterwards. If you have minor children, then you have to define who the guardian will be or the trustee will be for your assets. If you have one thing that I think our community, and that's from my personal experience and personal conversations, is a lot of special needs children. We do not have too much of, we haven't had too many conversations about making sure those children are taken care of as well. So there is, as part of the estate planning, you need to understand what are the implications of it if you have special needs children that you're leaving behind and what happens to them. So again, 3 things in the planning phase. What do you have? Who gets what? And then how will that be distributed or allocated to each of the inheritors? Now comes the execution part of it, and legal part of it we've already covered, so I'm not getting into there. I will talk about the execution part of it. Some of the areas where we've already spoken about, will. This is a simple demonstration of how a will works. Create a will during lifetime. Upon death, the will submits to the probate court. The probate court process decides and completes it, and then it gets distributed to the beneficiaries. It's a very simple, less expensive way of doing it, but it is also recommended for a very simple estate. If you have complicated assets, the complexities are different and requires a different solution to it as well. Then comes the trust. We've spoken about the revocable trust. Revocable, as the name suggests, it is revocable. Whatever you put into the trust, you can decide to take it out in your lifetime. You can make changes to the trust. You can decide to change the beneficiaries, decide to change the trust. If, let's say, what you decided to distribute today, if your health condition worsens and you need to use the assets, you can clearly do that and then leave the remaining to the inheritors. So it's irrevocable. It gives you more authority during your lifetime to decide what you want to do with your assets. Now, what is the other side of irrevocable is simply irrevocable trust. In an irrevocable trust, when you create the trust, you have to immediately sort of give the assets into the trust or transfer the assets into the trust. That is used mainly for tax purposes. People who have large estates and they don't want to incur estate taxes, they basically in their lifetime decide to donate or transfer assets to an irrevocable trust. So those assets move out of their estate and they don't get estate tax implications when the heirs inherit the assets. Now, like I said, it is irrevocable. Once you transfer the assets are transferred into the trust and you cannot make changes. You cannot decide to take assets out of the trust. They are gone outside of the trust. You've got the tax benefit for it. Now, it is whatever you decided at that time for it to be. Some of the pros and cons, I think I've underlined some of them. It shields assets from creditors and lawsuits as well. So those are mainly the reasons why people decide to set up an irrevocable trust. Why should you use a trust? We've already spoken about it. It gives you control. It protects your assets in case of lawsuits or credit protection. from probate process as well, keeping it private. Planning for disability, like I said, I think that is one area that we've not spoken about too much, is planning for special needs children, planning for disability for yourself as well. I mean, from an incapacitation point of view, that's an important point to consider. Death of a spouse when you don't have, if you're the surviving spouse and you don't have a spouse to inherit and you have to pass it on, and you don't have kids, or kids are of age where they're self-sufficient, in those cases, you may decide to have a trust to distribute the wealth. Philanthropic giving, endowment is a large part of it. Endowment, or even any other charity as well. And we will cover some of the charitable giving strategies that are commonly used to transfer wealth, or to give away wealth to charity. Avoid probate and real assets. One thing I've had in numerous conversations in the community members, or just the general Muslim community, is that a lot of people are immigrants. So we have assets either in Pakistan or India or somewhere which is still there. It's a family property. Unfortunately, after you pass away, a lot of children don't have any association with India or Pakistan anymore. So those are decisions where if you have assets outside of the country or even in different states, those are decisions that need to be taken in your lifetime, because your kids may not have the ability or access to those assets. If you're not planning for the estate, even if, let's say, assets are in Pakistan, and if you don't have proper estate planning done for the requirements of the state of or country of Pakistan or India, then unfortunately they will never have access to those assets as well. Now, one thing that I briefly touched upon is there's a trust for special needs as well. Now, why do we need special needs trust? Is because special needs children have a lot of government benefits that they can benefit from. And by setting up the trust in a specified way, you can make sure that the kids will continue to benefit from the governmental benefits, which is their Social Security, disability income, their Medicaid side of things, without compromising on their eligibility criteria. So those have some eligibility criteria. If you straight away pass on the assets to them, the assets are as it is of no use except for whatever the trustee decides, but they will also technically lose a lot of the benefits that they are eligible for from the government. Through a trust, you can make sure that they continue to remain eligible for those benefits while passing on the assets to them. One thing we spoke about was the beneficiary designations. There are a lot of assets that are transferred as a result of the beneficiary designations. Now, those beneficiary designations override a will. Even if you have decided in a will that you want to give away your 401k or your IRA to a child, specific child, or donation, a charity and everything, if you've defined it in a will in a different way versus your beneficiary designation on an account is completely different, your beneficiary designations will supersede your will. Your will not have authority to supersede the beneficiary designations. If you heard, I think it was last year or so, where somebody had a retirement account from way back in the 70s and his ex-wife was a beneficiary and it was $1 million account, did not care to change the beneficiary. The children and the current spouse did not get a dime versus the ex-spouse got the entire $1 million. That's how it is. If you don't change your beneficiary or don't update your beneficiary, unfortunately, that goes to whatever the beneficiary designations are. What accounts have beneficiary designations on them? Generally, and again, we live in a very complex financial world, so if you ask me a very complicated dynasty trust and everything, the answer would be very different. Generally, for common people, these are the accounts that would have beneficiary designations. Retirement accounts, your IRAs, 401ks, 403bs, your pension plans would have a beneficiary designation. Your life insurance policies, your annuities, your trusts, health savings accounts, and 529 accounts, the education savings accounts, would have a beneficiary designation on those accounts. The other way of looking at what happens to people, a lot of people have joint accounts, or your checking accounts, or your savings accounts, which are outside of the retirement purview. easiest way of giving access to the surviving spouse or whoever wants to inherit is have a joint account. A joint account classification, and there are some different classifications for that, instantly gives ownership of the account to the joint account holder. So if you and your spouse are joint account holder, even without going through the probate process, the joint account holder will have access to the accounts and your funds are not locked in. You know, he or she can access it for the final rights and whatever needs to be. So joint accounts classified in the right way can provide you that instant liquidity or ownership or access to the accounts. But it also has some downsides. A lot of times, or few times that I've seen business accounts where business owners have a joint account, and how many times have you heard that my business partner cheated me? Because joint account holders have equal access to the accounts, and if you have access, they have access. If they have ill intention, they can do a lot of things, right? So you have to be careful who you set up joint accounts with, and you know how much money basically you're putting into your joint account. But this is one way that people forget. They have individual accounts, individual brokerage accounts. To avoid probate process, have joint accounts. If you know there's nothing to hide, then there's nothing to hide legally. So that's one thing. What accounts allow you to have joint ownership? Your bank accounts allow you to have joint ownership. Brokerage accounts allow you to have joint ownerships with a transfer of death designation or registration on it. Some states allow for real estate and your car title to have a transfer on death deed. In case anything happens to you, the title deed can be transferred to the joint owner or the whoever you name as the transfer on death deed person to be. So that is one way of also looking at it, for the transfer perspective. This is a question that came up in the step up in cost basis. So majority of the assets do get a step up in cost basis. So from a tax point of view, from a spousal transfer point of view, it is very easy. Spouses can inherit majority of the assets, will get a step up in basis. If they decide to sell it immediately, there is no tax implications. If they continue to hold it and those assets appreciate, then there are tax implications for the inheritors of whoever inherited or spouse inherited and now has a capital gains tax or income tax on it if it's a short-term gain. Now, the eligible assets for a step-up very clearly is real estate that gets a step-up, primary residence, rental properties and stuff. Your securities, stocks, bonds, mutual funds, etc., get a step-up in cost basis. Your personal property, business interests, and other capital assets. Nowadays, you see crypto wallets, people invest in cryptocurrency, so they also get a step up in cost basis. But there are some assets that do not get a step up in cost basis. Your retirement accounts. So retirement accounts do not get a step up because, and these are specifically your traditional retirement accounts, which are your pre-tax retirement accounts. Because you did not, or you took a tax deduction when you were putting in the money, the IRS expects the tax to be paid, and they've given you, generally outside of the spousal inheritance, they've given you a 10-year timeline to withdraw the money, and on that withdrawal, you'll be paying taxes. So those assets do not get a step up in cost basis. Annuities, the cash value on annuities, or basically the death benefit that the annuities would pay, generally certain annuities do not have step up in basis. Your cash and bank balance does not have a step up, although the cost basis would be the same unless you have a savings account and stuff like that. Gifts made before death, there's a gift tax implication. So even if you decide to transfer assets in your lifetime, or if you give gifts in your lifetime, the current limit, I think, is the $17,000 per year gift tax limit, which you can give to anybody in your lifetime and not incur a gift tax. Anything above that would incur a gift tax as well. So you can plan it in a way where you can gradually give gifts to your children in your lifetime and not incur a gift tax.
How about life insurance?
For like a the death benefit payout. So certain life insurance policies have a completely tax-free benefit. They clearly stipulate that the growth would be tax deferred and the death benefit would be a tax-free benefit as well. But otherwise, if it is not stipulated, then they're not they're not exempted from tax, basically. So you have to pay capital gains, long-term gains tax on it. Special considerations for married couples. Like I said, we're in Texas is a community property, so the spouse gets the step up in her share of the property. The question I think that came where if the house is 600,000 or property asset is 600,000, 300 is my share, 300 is my spouse's share. The step up in basis in Texas would be the entire 600,000 would get a step up in basis. In states which are common law states, generally only the person who, the deceased spouse shares gets a step up. The surviving spouse does not get a step up. So that is a difference where depending on the state you're in, the guidelines would be or may be different in terms of the step up that you will receive. So step up is basically if you buy a house for, let's say, $300,000, and now the house value is $500,000. The difference of the $200,000, the appreciation of $200,000, that's capital gains that you've received. Now, you don't have to pay taxes on those $200,000 of capital gains because your cost basis would be stepped up. So your cost basis, which was $300,000, has now become $500,000. So you do not have to pay any capital gains taxes on it. If it wasn't a step up, and if you decide to sell this, say, the property or stocks, if without a step up, then you would have to pay the taxes on the capital gains of $200,000. So the step up means they step you up, or your cost basis get a step up where your cost basis will become the nominal market price, at that time. And then if you continue to hold the asset, let's say the property, the step up was $500,000, and then you continue to live in that property, and now it's become $700,000. Later on, when you decide to sell it, you will incur the $200,000 capital gains tax on it. So I hope I've explained the step up that you receive upon inheriting a property or assets, basically. If it was joint, so say a joint property, so even from like I said, the community property state, you would get a step up for that cost basis. Now the cost basis is, or the purchase price is not the $300,000, it is $500,000 for you as a owner of the house or inheritor of the house. So when you decide to sell it, you will not be selling it, like the cost basis will not be 300, it will be 500 for you. So even if you're a joint owner, but the step up that you received is going to benefit you when you decide to sell it later on. No, not for you. If you pass it on to the children later on, then yes, they would receive the step up when they inherit it. If you decide to sell it in your living, when the children inherit it, no, they will receive a step up. So their cost basis will now become $1 million, right? They will start, their starting point is $1 million now. When they goes to $1.3 million, they will pay the tax on $300,000. Yeah. Sorry, come again? On the primary residence, yes. But this was generally to explain so there are some exemptions on it, yes. The primary residence gets a $500,000 profit gains exemption. There are other ways you can do a 1031 exchanges and stuff like that for tax exemption, but generally this is the guideline for it. Anyhow, I mean, property, real estate, anyhow, that would happen. So even in a trust doesn't take away your taxes. Trust is only avoiding probate. Trust is only protecting your assets and stuff like that. It's not taking away your tax implications. So with putting assets in a trust doesn't mean you've avoided taxes. Taxes are still there. The step up will avoid the taxes. No, when they start withdrawing, so let's say you left a 401k for the surviving spouse, when they start to withdraw money from the 401k or now the beneficiary, 401k, they would start paying taxes on that value of withdrawal. Yes, yes. So their income tax rate, they will pay taxes on that, yes. Anything? So, yeah, I don't know. Sorry, I've been clicking it. I have no idea. Okay, special considerations for married couple we've spoken about. Irrevocable life insurance trust. That is also commonly used. It is a little complicated, but this is mostly used for charitable giving purposes. So a lot of people who want to focus on philanthropic giving, they utilize the irrevocable life insurance trust, where if they have a life insurance policy, they create a trust, and they transfer the ownership of life insurance policy into the trust. They basically pay the trust to pay the premiums for the life insurance policy, and then when they pass away, the death benefit is paid to the trust, and then the trust distributes, or the trustee for the trust distributes those benefits to the surviving beneficiaries, if you want to, or the charity organization that you would like to. So it's a way of getting, it's also, again, there's potentially less tax saving perspective, but more from avoiding probate, passing on the assets, avoiding creditors getting involved into this process as well. Those are the purposes where people use irrevocable life insurance trusts to transfer the wealth or pass on the wealth for their estate. It is irrevocable, like the name suggests as well. It's complex. It's a little expensive, but depending on your situation, it can provide you the benefit that you need. No, that can also be it. So one trust can serve that purpose, but a lot of people who want to keep their other assets in a revocable trust and only from a philanthropic giving point of view, then the standalone irrevocable trust can be created for that as well. Yes. Now, we touched upon philanthropic giving. So if you looked at the flow of the presentation, so we spoke about some of the asset protection reasons why people create a trust, the tax-wise as well, why people create a trust. The philanthropic giving or the religious obligations is where the big reason for also creating or looking at estate planning. Now, America takes pride in basically being a giving nation. Last year, if you look at the report, Americans gave $592 billion in charity. That is a record high which has ever been given. And majority of this money actually comes from individual givers, and it goes to the religious organizations. So giving to the religious organizations or supporting religious causes is the biggest biggest transfer of wealth that happens as well. And that is true for us as well. If we are in the room, forget about the Americans in general, if we look at in our room, I think our biggest charitable philanthropic effort is also going towards the religious organizations. Individuals make up 66% of the giving, whereas followed by the foundations, which is, I think, 18% of the giving in total as well. Like I said, the entire or majority of the giving goes to religious organizations, followed by humanitarian services and education. I just wanted to set the context that, in general, we're a giving nation. We're people who give. And also, if you look at, this is one of my presentations last year was to build a resilient community. In the world, we've got almost over 50,000 Imam Bargas and Azakhanas that are, currently sort of from a census point of view. It may not be the accurate number, but the estimate is it's over 50,000 Azakhanas. Guess how they run? They run on the support of people. They run basically on the philanthropic giving of people. So if the philanthropic giving was not there, we would not have institutions like we're right now sitting in. Now, the benefits of, from a philanthropic giving for religion is, of course, fulfilling the religious obligations. Philanthropic giving has a lot of tax benefits as well, where you get deductions for your charitable giving. You avoid or defer capital gains taxes, and we'll cover some of that in the coming slides. You can control the timing and where you want to give as well through some of the structures. Portfolio management for high concentrations, simplified accounting, tax-free. More importantly, it's about leaving a legacy, whether you want to be remembered for the dynamite or for the Nobel Peace Prize. Now, 2025, I just wanted to put in, just to kind of make sure people are updated. So 2020, there's a lot of changes that are coming in 2026. The one big beautiful bill that was announced by Trump earlier in this year has made some changes into the philanthropic giving as well, which makes 2025 more attractive for people who are planning on giving large amounts of money or a decent size of, as a philanthropic giving. Now, from 2026, the standard deviations have been increased. Standard deviations have been increased even from 2025 to 15,750 for single filers and 31,500 for married filing jointly. So your standard deductions will be higher in 2025 or starting 2025. However, for itemizers, there is a floor and a cap that has been set. Now, people who were giving significant amount of money and they were itemizing it, or they had a lot of tax deductions, now there is a floor and a ceiling. The 0.5% floor that your tax deduction, and I don't want to get too complicated, is you will not get deduction from the first $0 or $1 that you give. You will start getting deduction from the 0.5% of your AGI, and it is not an unlimited. So if you're in a 37% bracket, you're not getting 37% or 39% deduction. The cap is 35%, so your cap will be at 35% of your AGI. So your deductions would be bracketed a bit. But for non-itemizers, you will have an additional deduction for your charitable giving, which is $1,000 for single filers and $2,000 for married filing jointly. So you'll get some more additional benefit in your tax filing from 2026 if you're a non-itemizer. Corporations have corporations which made philanthropic giving will only be able to get deductions from like 1% of their taxable income, and cash gifts that is permanently 60% of the AGI. We'll cover some of that later on as well. Now, what is the best way, or what is the most efficient way that everybody gives? Of course, cash donations, or we do electronic transfers, or we do cash donations, or we write a check. Simple flow of how it works. You decide which charity to give to. Can be a one-time or a recurring donation. You transfer funds directly via a check or cash or whatever. Charity gives you a receipt for tax deduction, and you go on and get a tax deduction at the end. That's a very straightforward. It's an immediate impact. You're giving it in cash. The organization's getting an immediate benefit for the cash as well. However, the other most common way that a lot of people not think about it is when you're taking distributions from your retirement account, you can simply change those distributions to make them a qualified charitable distribution, which means that you're converting your retirement account distributions to go to the charity, and that deduction, and I think the relevant question that came in, so that deduction or the distribution that you get from your retirement account, which is a taxable event where you will be taxed, making it a qualified charitable distribution for your homes payments or sadaqah payments or anything that you want, you can get the tax benefit for it. So you don't really have to give cash. Instead, you can just redirect your retirement account distributions to make them qualified charitable distributions to make your religious obligations and get a tax benefit or potential tax saving as well. This is limited to IRAs. So people who are working and in their 401ks, you don't really have this benefit of making your distributions into a QCD. There is an annual cap of $100,000, but even getting a benefit of $100,000 is a significant amount of benefit that people can utilize. Donor advice funds, they are becoming increasingly common, and a lot of people are taking advantage of it. It's simply your own private foundation. So when people ask, can I set up my own private foundation for charity, donor advice funds will allow you to pretty much do that, except for maybe some caveats here and there. So donor advice funds are simply an account, a charitable account, where you transfer the money, you get immediate tax deduction, and then you don't have to give that money out to charity immediately. You can defer that charitable giving in later years of your life. So while you're working, a common example where people do is if somebody's got a bonus, which is a significant amount of bonus, which moves you into a very high tax bracket, put some amount of money into the donor advice fund, which reduces your taxable income, which gives you that deduction, and then use this amount later on to pay your homes or sadaqah or whatever you want to do from a charitable point of view. You can always do it later on. Those funds can remain invested for it to grow over time. So you can get benefits of both investments, but at the same time get an immediate tax deduction, reduce your taxable income as well, and potentially benefit from giving to charities for the rest of your life later on. So donor advice funds are increasingly becoming popular with people for charitable giving. It's a cost-effective solution, and it's quite easily accessible as well. Yes, it would make more sense if you have a large amount of sort of deduction that you require, and if you're bunching your future giving into the current year, that's where it will provide you the benefit of it. So that's for example I gave. If you have a significant amount of bonus that you've received, you can do that. If you have significant amount of appreciated stocks, which has a lot of capital gains on it, and you don't want to incur those capital gains, you can transfer those stocks into your donor advice fund and get the deduction, and they remain invested and continue to grow, and you can give it later on. First question, I'll take it in a minute. Those are institutions. So those are institutions. So like Fidelity Charitable, I work for Raymond James Charitable. So those are professional organizations which have those accounts. So it's just like a 401k, where the 401k has a team behind it which is managing all of it. From an investment point of view or grant-making point of view, you just have to direct from your donor advice fund, say, give $10,000 to IEC endowment or whatever the EIN number is. Cap on putting money or going out money? Putting in money? No, there's no cap for that. Yes. Sorry, come again? No, there's no cap for giving out as well. Yeah. Yes, so registered United States public charities, not even private charities, public charities. So anyone who has an EIN number or is a 501c registered 501c3 organization, that generally would qualify for it. Yeah. Yes, sorry? Yes, it should qualify. Yes. From 2026 onwards, yes, it would. Yeah, it's just a lesser benefit that you're receiving from 2026 onwards. So 2025 is a better opportunity. Donors can only recommend grants. Okay. Right. It's not discretionary. It's not like they will, just because it's a Muslim organization, they will decide not to. If that doesn't meet the IRS guidelines. So I'll give you an example. A client who is a doctor with the Pakistani Physicians Association, APNA. So now APNA is a 501c3, but it is a private 501c3, and it doesn't have some track record. I think the IRS has some guidelines of 5 or 7 years of operations or whatever. Yes, that money could not go to APNA. But if it is a registered 501c3 and it meets the IRS guidelines, it's not like they will just refuse to do the grant. Yes. Yeah. So I think the question was, and they wanted me just to highlight, so donor can only recommend grants. Over here is basically, it's a process where a donor or account holder will recommend the grant, like give $10,000 to IEC, but the processing of it is the responsibility of the organization. So the question was, would they refuse to give money? If it doesn't qualify for IRS requirements, it's not like the company has a discretion over deciding, no, I don't want to give your money away. If it doesn't meet certain requirements, yes, but generally, if it's a qualified organization, they would not stop the money. Right? Let me just complete it. If anybody has any questions, I think we're probably over time. Charitable remainder trust is another big one where, as the name suggests, the charitable remainder of the trust goes to a charitable organization. In between, the income can go to the beneficiary. So if you're looking at supporting your family with income, but you want to pass on everything else that's remaining to a charitable organization, you can use a charitable remainder trust. A charitable lead trust is the opposite of it, where the charity gets the income throughout the lifetime, but the remainder goes to the beneficiaries that are there. So charitable remainder and charitable lead trust, private foundations, I don't really want to. This is one of the key questions that comes up every time of donating appreciated stocks. So when you donate appreciated stocks, just as an example, if the stock price is $5,000 and that has grown to $25,000 now, you want to give that $25,000. If you were to sell the stock, you would incur a $3,000 capital gains on it, which you would pay to the IRS. You would give $22,000, the remaining amount, to charitable organization. You would get a tax deduction of the $5,280 as a result, and your tax saving after paying the $3,000 long-term gains is only $2,280. However, if you just donate the stocks directly, you're getting the entire $6,000 as a tax benefit. So consider donating appreciated stocks. That's why the endowment is there, where if you have stock options, I personally, if somebody asks me for cash, I may think twice. If somebody asks me for my Raymond James stock options, I will give it because I know next quarter I'll anyways get new options available to me. So it's an easier way of giving. Donating private stocks, business owners, you can give away your business share as well. If you're planning to liquidate business and as part of your philanthropic effort would be, I want to sell my business and then I will give money to the IEC endowment or whatever. If you sell your business, you have long-term gains tax to pay, and then your net amount donated, $80,000. If you're directly passing on the share of your business, whether endowment accepts or not is a separate question for that. But it's a possibility which happens in the real world where people do donate their shares of their startup company or as a business as well, and they get a potential tax benefit for it. Roth conversions is a big conversation that happens. A lot of people prefer Roth conversions because Roth accounts give you tax-free income. I can go into details if you have any questions on Roth accounts, but Roth accounts are basically tax-free accounts which are highly recommended for you to have. If you're doing conversions for Roth or you're doing Roth conversions and you're thinking of later on doing charitable giving as well, having a donor advised fund with a Roth conversion can give you potentially more tax savings than individually just doing a Roth conversion and then later on deciding on what the charitable giving would look like. The endowment, I wanted to touch base on the endowment, and I'll come to the question, the Sawab-e-Jariya concept. So we have, it's something which started with the Muslims, and I don't understand Muslims have not utilized this benefit in the best possible way, where there's other communities that have tremendously benefited from endowments. What are endowments? It's a one-time gift that you give to the endowment and you reap the benefits forever. Even when you're not alive, you will still reap the benefits for it. So say you give money, and I have next example for it. So let's say you set up an endowment for $100,000 in the first year. Your year one available grant is $4,000. So let's say the endowment has a condition that they will use 4% of the endowment value for the purpose of the endowment. So they take 4,000 for, say, IEC operations, and you get the benefit for it, of course, as a sawab. Now, fast forward it 15 years down the line, your $100,000 has grown to $147,000, and your annual grant from $4,000 has become $5,500. And over these 15 years, you have already given almost nearly $70,000 to support IEC, its operations, or whatever the purpose is. Fast forward it to 50 years of it. Your $100,000 has grown to almost $370,000. Your annual giving has grown from $4,000 to $13,000. And during the course of this time, you have actually given away nearly $400,000 to support IEC. So a one-time gift now can result in a large sort of support system for the organization and the future benefit of the organization. There's a real-life example, and you can go and Google it. It's a New Jersey school, a Torah Academy, a Jewish school, a Jewish day school, which actually did not have, it started with a day school. One of the parents of the school, the child's parent, actually challenged the school to that he would donate $1 million to the endowment of the school if the school is able to generate another $1 million. The school thought it was a good opportunity to get the money. They started an endowment effort. Fast forward, I think 2 to 3 years, they were able to raise the $1 million in their endowment. They got the $1 million from the parent as well. Now, today, that entire school is run through the endowment. The school is free for cost. It is run on a merit basis. They don't charge parents to pay anything, to pay any fees. Whatever parents want to give, the money can be paid into the endowment of the school. But the school is run cost-free by support, from the support of this endowment that they started. So one little step can go a long way. It is a real-life example. It has happened, and it can happen, for us as well. I think we've covered the wealth transfer story. There's a lot of potential wealth transfer. For us over here, I think the way I say is that our priorities are not the same as our children's priorities. They will think very different. They will give very different. They have their own priorities. Now, what we want to do, if we have to support, we do it in our lifetime itself, and we make those decisions, because in the next 25 years, there's $124 trillion that will change hands, and those changing hands will come at their own risk. 20% of the Bitcoins have already been lost. They are not trackable. They're completely lost already. We've not even completely mined Bitcoin, for those who know what Bitcoin mining is. We've not completely mined Bitcoins, but 20% of it is already lost. $5 billion annually go into unclaimed assets because the heirs don't even know about those assets. People have not had conversations with their children about what money they're leaving behind and for whom, and those go completely unclaimed. In the United States, estate proceeds rank amongst the most commonly abandoned assets. So estate proceeds are never claimed because the next generation of people don't even know about it. And globally, it's a much larger number. We live in a digital economy. Everything is digital. Unless people have access to your digital accounts or know about them, they will never be able to claim them. Childless inheritance puzzle, another issue, cross-border chaos, blah, blah, blah. Okay. Why do estate plans fail? Because family changes, assets changes, our location changes. We're fairly mobile. These are all. So that's what I had for you. I don't know how much it was useful, but if I put you to sleep, then I think I have succeeded. Oh, no. Sorry. I should have put the slide on there for my contact, but I will give you my contact. Any help I can do, or at least from a guidance point of view, I will be happy to do that.
Thank you. Thank you, Brother Ali. We'll open it up for Q&A, and if it's okay, what we'll do is we'll invite the speakers back on stage. So if Maulana, please, and Sister Sidra, if you can come up. And if you have, yes, thank you. If you have questions, if you have written them down, just pass them to me. I'll read them out. If you want to, otherwise, if you want to raise your hand, we'll try to get to you as well. And I'll start with a question that came a few minutes ago for Maulana. Question for Maulana. If a child leaves Islam and becomes a Christian, is he still eligible to inherit?
Well, Assalamu alaikum again. Yes, irtidad is something disqualify a person from inheritance. But again, I have to double check. If you have this question, you can come back. And I was just openly, just generally looking, it was saying irtidad, which means someone is leaving Islam. Now, is that just about becoming an atheist, or is still about the Ahlul Kitab? I have to double check, inshallah. You can come back to me and I will answer you, inshallah.
I think, what about the 1/3 share, the wasiya? Can you then transfer it to your Christian child?
1/3, yes. 1/3, it's your own like decision, right? You can do it.
This is again the text question. Out of the list of designated beneficiaries for all the different accounts, retirements, insurance, Roth, everything else, which according to you is beneficial for both of you? And this is the question for both Ali and Sudra. Which is beneficial to have a transfer to the trust, or which is beneficial to just keep it as a designated transfer?
Could you please also state who the question is for?
So, yeah. So the question is, and I'll repeat, if I repeat it wrongly, let me know. So our question is from the accounts that we listed as beneficiary designations. What do we suggest are the most beneficial accounts to transfer to the trust, and what not to transfer and leave it as beneficiary designations, right? Anything that has a beneficiary designation remains as a beneficiary designation. I think and correct me if I'm thinking it wrong, I think you're asking about the joint ownership, the transfer on death or transfer of deed thing. Those ones you can decide, so like if a joint account, like a savings account or whatever, if you want to put it in a brokerage account or anything where you can name it in the name of the title, like a brokerage account or a savings account, and put the money over there. That can be done in the lifetime. But if it's strictly a beneficiary designation question, that has to remain a beneficiary designation. Only the beneficiary on that will become the trust. So your retirement account's beneficiary would be the trust. Your insurance policy beneficiary would be the trust. So beneficiary designations will still remain. It's just that they will move from an individual being named as a beneficiary to the trust as the beneficiary.
So if you want your trust to have, if you want the asset to flow through the trust, then you add the trust as the beneficiary. You are saying currently you name the trust as the owner of the investment account. You have the option to do that. If you're doing a revocable living trust, I don't see any benefit to doing that, having the trust be the current owner. I would suggest having the trust be the beneficiary so that it still flows into the trust, but it'll go based on your trust terms. Unless you have some sort of, like you want the trustee to manage the investments.
I think the question is more from a tax point of view. So the trust pays the tax versus you pay as an individual the tax. It would again come down to your individual. If your individual tax rate is lower, you'd rather prefer to keep it as a lower individual tax rate rather than moving to a trust where you're paying a higher tax rate. But if you're in a state like California where your combined tax rate of Federal and state level tax is almost 45, 48%. You're probably better off leaving it in the trust and using that. So individual situation, without knowing, I think that it would boil down to the tax rate itself, because that's the only benefit you would receive by naming an account in the trust versus keeping the account as in the individual name.
So if you have an investment account or share or trust account where you have shares, when the shares are transferred, no capital gain tax will be applicable at the time of transfer of your death?
At the time of transfer of death or transfer to the trust?
Title to the trust. So like now I'm dead. Yeah. On my foreign will, I have basically told that this account will be basically transferred to the trust name. At that time, they will transfer from my name to the trust name. The capital gain tax will not be applicable at that time?
Not that I think. Only it will be when you will sell the shares, or whoever will sell the shares.
Yes, Assalamu alaikum. Maulana, this is a question for you. In Islam, does a person have the right to delay the inheritance to his adult children? Like Sister Sidra was saying in her presentation that you can name them after they become 25 years old. But if your child is 18 years old and when you die, do they not become the right owner right at that time? Or can you have the right to delay it for 7 years or 8 years or whatever age? Thank you.
So, Bismillah ar-Rahman ar-Rahim. Yeah, there we have like a conflict between legal and Shari'i. Whenever, if the Warasa, these children, they says, I need my legal right now, they can get it. If they agree, that's fine. I can wait till 25, then again. Otherwise, the Shari'i law will override the legal for the Shari'at purpose, not for the legal purpose, right? If this child is Safi, which is not incapable, then need to go to the guardian. I mean, that person can use it, but through guardian, guardian, right? But as soon as it's 40, right after the death, they have, if they demand, they have to distribute the assets, right? Thank you. It's a good question. Now, can I have two clarification, right? When I was talking about what are the conditions for person who is writing a will, majority of the time I use he, that doesn't mean that female cannot, okay? In Islam, everyone who owns something can write a will, female or male, okay? The other clarification I like to do, because in the on my last slides, I was going through real fast. There was one slide where it has that if you have multiple gift, multiple bequest, and again, let's say you're 1/3, that multiple, all of them combined is more than 1/3, that which one will take precedence? Normally they say is the first one, right? The top one. Or unless you have indication that these others, right? So that was the confusion. Now, one other confusion is like, let's say if I have a multiple wills, and it's proven that it's written by a Musi, like that person who wrote that, then again the last one will take the precedence, right? The last one, yes. Thank you. Jazakallah.
Question for Brother Ali. If a property has been given to an endowment fund, can it be sold and can another property be purchased?
It can be sold by the endowment. If you've given it to the endowment, then if the endowment decides as part of their allocation, if you've left it as a bequest, which means that upon your passing, the property should go to endowment, then in your lifetime, you will have to, of course, update your bequest or whatever you've written to update the property address and the details of it. But in your lifetime, yes, you can decide to take it back from endowment or like change your will. you can do anything with that. But if it's passed on to the endowment, then it's the endowment's responsibility of what they do.
Okay.
Let me add to that. The way I see endowment fund is set up, if somebody donates a property, I see endowment fund is not a business of maintaining property. So what we will do, as soon as we receive the property, we will sell it. And the funds will be invested like other funds we have in endowment account.
Right.
So this is clear,
Right, yes.
Another question for Brother Ali. You mentioned about converting to Roth with a donor-advised fund. Isn't it better to give a regular IRA to a charitable org?
But there is a cap. So the $100,000 cap that you have for regular sort of appreciated stock, or not appreciated stock, but like from a traditional IRA to receive. And the tax benefit is also limited. But if you do the Roth conversions can be of a higher amount as well. So you can do a $500,000 Roth conversion. But if you combine a Roth to the maximum possible limit, which will help you with taxes, that is usually the best strategy for it. You can donate, yes. Directly from the traditional account, you cannot. Traditional IRA, you cannot. You will have to take the distribution and then donate it. So either you take the distribution, then donate the amount, you will have a taxable income problem. But if you do the Roth conversion with the donor advised fund, that would save you potentially. So, yeah. Yes, you can leave the beneficiary on your retirement account as the endowment fund, and whatever remains in your retirement account at your death will pass on to, so yeah, so that you will, yes.
A question, this is about endowment fund. Can I ask to have some amount of the money from the endowment fund to be towards my Majlis and Ramadan funds after my death from the endowment fund?
I think that's an answer for the endowment committee. Well, right now, I think, and if I
would try to answer that. Right now, we don't have any provision. So probably they will donate it to the VIP, and they may do some arrangement like that.
It's towards the operation of the IC, and the operation of the IC is technically all the fees, because the madaris and all that.
Yeah.
So the question is again maybe on the same ground, that if the distribution for the endowment can be, can a donor can just like specify that this should go to the Al-Hadi school fees. Like you gave the example of Torah, not to the operations of IEC, but specific to the education purpose of student fees. Scholarships and anything. Is this IEC, like it's already?
Not in the current capacity. So currently it is general. It'll go into the general funds, the project 10K or 20K. So that's the first step, I think, of the endowment, is to become self-sufficient, where we can replace the project 30K with endowment. So endowment supports the entire 30K project. And then I'm sure later on, as we grow as an organization, we can always consider a scholarship fund separately or whatever. But yeah.
So let me have one explanation, because earlier you asked about the beneficiary, right? So the fatwa is that as an ehtiyat, as a precaution, beneficiary cannot be murtad fitri. Let me explain that terminology. Murtad fitri is someone who born as a Muslim and then he renounced Islam. Okay, so that's called murtad fitri. What's murtad ghair fitri? If someone's a Christian, became Muslim, and then he renounced Islam and went back to Christianity. So that's not Murtad Fitri. Murtad Fitri is someone who born as a Muslim and he renounced Islam. Whatever religion he go, he cannot be, as a precaution, cannot be beneficiary. Second question is, what about the non-Muslim, any non-Muslim, like a Christians or a Jew? The condition is that person should not be kafir harbi. Kafir harbi is someone who imposes war on Islam. Let's say a Christian Zionist and that person is imposing war on Islam, that person can never be a beneficiary as per Islamic laws. All right, thank you. Jazakallah. So they, like someone renounced Islam and then what happened? Again, as I said, that inheritance cannot go to the murtad. Cannot receive it. If you receive and then do it, then again that's a separate story. Before receiving the assets, if he do it, and again, wasi, that in the guy who is like implementing it, he need to make sure that it should not go.
Can we please limit to one question per person? We have a lot of questions to cover. Okay. Brother Ali, if you have a designated beneficiary, both primary and secondary, in all banking accounts, do you still need to have a trust?
It depends if you want to avoid probate. The benefits of trust, I mean, if those are something as your consideration, if probate is your consideration, privacy is your consideration, minor children where you don't want them to inherit money all of a sudden and you want to control the assets for distribution, if those are the considerations, then yes, you probably want to have a trust. But if it's purely simple transfer, then I don't see why you want to have a trust when it can simply be transferred to whoever inherits it. So if it's a simple case, you don't need it, but if you need the benefits of a trust, then you need a trust.
Brother Ali, by the way, excellent speeches by everybody. Say salawat. If you can clarify between QCDS versus DAF, what the pros and cons of both?
So QCDs are basically the distributions you're taking from your retirement account. Now, you can decide to take as much as you want as a distribution once you're qualified for it. In a QCD, you can only do it after you've turned 70 and a half, not before that. And again, like I said, it cannot be done from a 401k. It only has to be done from an IRA. So there's certain limitations on that. And then I think the QCD had the maximum limit of $100,000, which can be converted to a charitable QCD. Whereas for DAF, or Donor Advised Fund, you can decide to give in $100,000. But Donor Advised Fund contribution will be by taking the distribution, which will be a taxable event, and then giving into the Donor Advised Fund. So it's a different transaction versus QCD goes directly from it never comes to you. It will directly go from your retirement account to the designated charity. And there are certain limitations on QCDs. Right.
Question here. Does a step-up basis apply when jointly owned primary residence is transferred via transfer on death deed?
If the person inherits, yes, you will get a step up. So, unless I understood the question wrongly, but I think, yes, you would transfer of death. So I'm assuming, yes, one spouse passed away, you inherited the property fully as a surviving spouse, you will get a step up in cost basis. So now that is your starting point. If you decide to sell it immediately, you don't have any gains taxes. But if, let's say, the house value has gone up from there, then you have capital gains taxes. So, yeah.
My question was for Maulana. If someone, just a
That's why now, that's why we said that if you have anything qaza on your neck, that wasiyat become wajib, right? Because they're not obliged to do anything. All they do, they receive the inheritance, right? If they're good, they can do it. It's, again, up to them. Islam is not enforcing them to do it. Only Islam is recommending that if there is like any obligations of your father, pay them. Like if you didn't pay the homes, pay the homes. If you didn't pay, perform the Hajj, perform Hajj, and all those other things. That's why it's wajib in this case. If you have any debt or anything which you don't know if your inheritors will do it, write down the wasiyat. Highly recommended. And again, you have the right of 1/3. You have a right of 1/3. Because again, you know that when money comes, again, it's very hard. That attachment with the money is, they said, all right, my share, I have all these problems. Inshallah, I'll do it for my dad later on. You just take that right of 1/3.
I have a point here, Maulana Sahib. You know, regarding the question the gentleman asked, I knew a situation where one of my friends passed away, and I found out that he owed some money to some people. So I talked to you or some another alim, and they suggested that I tell his children, and because they are the inheritance of his assets. So I did that. I passed that information to his children, but I did not follow whether they paid that loan or whatever or not. So I thought I was done with my obligation. Am I correct?
Yeah, you're right. Again, because again, if the inheritors, they receive a estate or funds, and if they know that there was like some debt and some other thing, they need to remove. Remember that formula? First you remove all the obligations, all those things, and then 1/3, and then inheritance. Yes, you did right. Yes.
Just like we are recommending people to save some money for themselves, most of us don't use up our entire paycheck. We put some money in 401k, this emergency fund and so on. So IEC board, and please make sure the IEC board of directors can agree to transferring at least a couple of % of your income, and it will not be missed to the endowment fund every month. I know of an institution, the advisor goes there and picks up the check every so often. So please implement that. That will be a way of telling people to endowment fund by showing an example. The board, if they take this example, others will follow. And secondly, most of us have been hearing a lot of good information here. My simple advice to all of us is to set up a goal, especially for the Nazar one, that I would like to donate, say, $100,000 in my lifetime. Maybe you don't have all of the $100,000. Put whatever you can give in the beginning. Pledge to give them every month. Some people have done that. Maybe $1,000 and 500, whatever they are making percentage for that, and maybe you mentioned 20K, small amount for that, and God forbid something happens to you, back it up with some insurance if they need to. So make it a plan that you want to give $100,000, $1 million, whatever it may be, but have a plan. Put this as an important factor before you leave here. Before you leave, all of you, if possible, don't wait for a call from these people. Sign up and say, I'm available to talk to you at this time. Please don't wait to call any of them. They have doing their job. So sign up and say, Ali, call me at 7 o'clock evening tomorrow. That is the way to act. Otherwise, you forgot me. You say nothing to come back. You all family without any action. So I humbly request to follow up, implement it, and get done. Because I have gone through things are easy to forget. So sign up with the sheets. For the first 10 people are signing up, IC can provide you with lunch certificate. How about that? Can you do it? So the first 10 people who sign up for an appointment will get a lunch certificate from IC.
We can definitely do that. And just to add to that, it doesn't have to be 100,000. You can contribute in small tips, like you can have $100 a month, you can set it up, that's completely fine as well. Over your lifetime, it's not going to contribute.
want to donate 1%, but I would add to it that you must have a goal. Putting $50 is a very simple thing to do. It's difficult to start with. Unless you have that goal, you not even put it on your bill. Unless you have that idea that I'm going to give $100,000, you will make sure that you will, well, I can't do it in my lifetime. At least $100,000 standing at my desk. Thank you.
Thank you. And with that, on that note, let's end the session. Thank you so much to our speakers here for all the great information we got today. Salawat, please. Dua.
And let's have a loud salawat for Brother Mohsin. MashaAllah, he conducted a great job. Allahumma salli ala Muhammad. Let's have a group picture here with the speakers and the audience, please. Aye. 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 All the boys, please come to the podium.